Mr. Williamson, you ready to proceed?
If I would have 1 moment to fire up my computer.
All right, sir.
Be ready. Thank you, Mr. DeVore. I'm ready.
All right. Will be additional evidence for the state.
Yes, Mr. Chair, the state would call Grace Humphrey to come around. Humphrey, this would pertains to claim 2.
Good morning, Ms. Humphreys. If you just stand there, place your left hand on the Bible, raise your right hand, face the clerk. Do you solemnly swear the testimony you're about to present to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, please be seated.
Ms. Humphreys, please check, make sure your mic is on. It should be a,
Yes.
okay. If you would, when you get settled, tell us your name and where you live.
My name is Grace Humphrey, and I live in Southport, North Carolina.
And had you formerly resided in Alamance County, North Carolina?
I did.
Were you part of a legal proceeding in Alamance County, an equitable distribution matter, captioned Grace Humphrey versus James Humphrey? It was 12 CVD 1672.
Yes, I was.
And was judgment entered in the equitable distribution case on or about August of 2015?
Yes.
Was it your intent to appeal that judgment in that case?
Yes, sir.
And did you hire anybody or consult with anybody in terms of appealing the decision in the equitable distribution case?
I did.
And who was that?
That was with the appeal law group, and it was Patrick Megaro.
Now, you're talking about the defendant seated at the far table on the far side?
Yes.
Is that Mr. Megaro?
Yes.
Okay. And how did you come to locate Mr. Megaro or choose him to consult with appealing this matter?
It was basically through the internet, trying to locate someone that would be able to help me with appeal in North Carolina. And so when I found Mr. Megaro and his law firm, I saw that he not only was in Florida, but as well as North Carolina. So I reached out to him directly through an email.
And did there come a time when you hired him to represent you appealing the equitable distribution case?
Yes, sir.
Tell the panel how that came about where you met, or did you actually meet face to face with him before you hired him?
I did.
Tell the panel how that happened.
When we were deciding what would be the easiest way to meet due to his situation, mine in different states, he had told me that he was going to be at the Raleigh-Durham Airport dealing with some other things and other cases, and he would be happy to meet me. So we met at a little coffee shop, like a little Java coffee shop. And so we sat down there, and that's when we discussed the case and went from there.
And that would have been sometime September of 2015?
Yes,
And did you enter into a legal services agreement with Mr. Megaro?
I did.
And if you would pull up, one moment, Mr. Chair. Now, over to your left, there's a screen, and if you need us to scroll through the screen, this is Exhibit 723.
Yes,
We'll scroll through it so you have an opportunity to look over it. Is this a copy of the legal services agreement you had with Mr. Megaro?
it is.
Now, did you have any experience? You're not a lawyer or anything like that.
No, sir.
Were you ever have work in a law office as a paralegal or anything like that?
No, sir.
Did you know anything about North Carolina appellate procedure in terms of perfecting an appeal and getting a matter before the appropriate appellate court?
No, sir.
And did you rely on Mr. Megaro's expertise as a lawyer to be able to do that for you?
Yes, sir.
Now, according to the certainly the legal services agreement, you were required to pay him some money. Did you do so?
I did.
And how was it structured, or what amount of money did you pay him?
It was a $3,000 retaining fee.
Okay. And I think the total fee was going to be $10,000.
It was.
And how were you going to pay the remaining part?
He allowed me to pay $3,000 up front, and then we set up a payment plan that came directly out of my checking account starting November of 2015, the first of every month. And so it was $500 that would come out automatically.
And did that occur until a certain time period?
Yes.
Do you know how much total how much do you say you totally paid Mr. Megaro?
Around $5,700.
Did you, did there come a time when you learned that there had been a motion filed by the appellee, I guess your ex-husband's attorneys, to dismiss your appeal?
Yes.
And when did you first come to get any information about that?
It was several months later. I believe it was around the time that a cert was filed, somewhere around there, and it was explained to me that they were, basically blocking us, so we were going to have to take it to the next step. But I was really not sure why they were trying to deny the attempt for an appeal until later.
Now, you said something about cert. At some point, did Mr. Megaro file a petition for writ of certiorari in your case?
Yes.
Okay. And was that after the direct appeal, the initial appeal, had been dismissed?
Yes.
Let me refer you to Exhibit 190. And we'll scroll through. Can you tell us what this is? Or have you seen it before, first of all?
Yes.
And what is this?
I believe this is the was this from Judge Lambeth, or was that from the attorney?
The end of it.
Yes, Judge Lambeth.
So this is an order dated, filed on April 26th of 2016, dismissing your appeal. And it appears that two of the grounds for dismissing the appeal were that there had been a non-compliance with Rule 7 of the Rules of Appellate Procedure. That's at paragraph 2.
Yes,
Not filing the transcript within 14 days of filing the notice of appeal, or making arrangements with the court reporter within 14 days.
yes,
And then the second ground is failing to file the notice of appeal timely.
yes,
And this shows it was entered on, it was filed on the 26th of April 2016. Did you know at the time that your appeal had been dismissed at this time?
no, sir.
And you found out later when there was a cert petition?
Yes,
Was it your responsibility to get the contract with the court reporter filed on time?
no, sir.
Is that what you hired Mr. Megaro to do?
Yes,
And did you know anything about putting together a record on appeal?
no, sir.
And did you assume that responsibility in the relationship you had with Mr. Megaro?
I did after a few months when I was not given a transcriber.
No, I'm talking about the filing the record on appeal. Did you have any experience with?
Oh,
filing
no,
rec-
sir. No, sir.
Now, it appears, let me refer you to Exhibit 722. And we'll scroll through that. And let's go down to page 23. Now, this appears to be a transcript of a proceeding that took place on March 2nd of 2016, a hearing on a motion, the defendant's motion to dismiss the appeal. At the time, have you had an opportunity to see this transcript?
I have.
And let me refer you to, well, first of all, do you know that there was an earlier hearing where the appeal had been dismissed, but because Mr. Megaro did not appear for the hearing?
Yes,
And then there was this hearing took place in which he called in.
correct.
All right. Let me refer you over to page 23. Actually, 22, let's start there. Down at the bottom of page 22 of the transcript, do you see where Judge Lambeth is talking at that point?
Yes,
It says, all right. So it's supposed to be done in 7 days, right? It should have been done 6 weeks earlier, -- 5 to 6 weeks earlier. Then he continues on the next page. And so that clearly wasn't dealt with. Also, the proposed record would have been 35 days after that. That has not been done until well after. So were there any rules that weren't violated? And then Mr. Megaro responded, well, those are the only two that are really applicable at this point, Your Honor. I mean, I think we're still stuck in the record on appeal stage, and then Judge.
The objection is that this is not questioning testimony by reading.
Ask your question.
Okay. You've seen this transcript before. Do you know what Mr. Megaro's response to the judge was after he asked what the question at line 9?
yes.
What was his response?
Would you like for me to read it or in layman's terms? Okay. Mr. Megaro said to add a little levity to the situation. I haven't had a chance to violate any more yet. Give me time.
And the order speaks for itself. Your appeal was dismissed.
Yes, sir.
And I think you said later, Mr. Megaro pursued a petition for writ of certiorari.
Yes.
And was that denied also?
Yes.
Now, did you call the Court of Appeals to find out what had happened to the court, to the petition for writ of certiorari?
I did.
And did you speak to somebody there?
I did.
Was your petition for writ of certiorari granted or was it denied?
Denied.
All right, so your appeal was lost.
Over. Yes.
Are you pursuing a civil action against Mr. Megaro regarding him not having perfected your appeal appropriately?
Yes, I am.
That's all the questions I have at this time.
Cross-examination.
Thank you, Mr. Zor. Ms. Humphrey, I know we've met briefly before down in Brunswick County. You know that I'm Wayne Williamson representing Mr. Megaro in this matter and also the civil action that you brought. Now, you are currently suing Mr. Megaro in Superior Court in Brunswick County, North Carolina for legal malpractice, correct?
Yes, sir.
And that lawsuit is based really upon the same facts and so forth that you alleged in your grievance against Mr. Megaro, correct?
Yes, sir.
And you've not been deposed or put under oath in that lawsuit, right?
No, sir.
Now, how much money are you asking for Mr. Megaro to pay you in that lawsuit?
Objection.
Overruled. Ms. Humphrey, when I've overruled the objection, you may go ahead and answer.
I believe it was through his insurance carrier, and I believe the, I guess, the most that it can be paid out, I think it can vary anywhere up to $1 million, I believe.
So are you seeking $1 million for Mr. Megaro?
Yes.
Now, let's go back to your divorce case against your husband in 2012. Now, during the course of that divorce case, the judge ordered you and your ex-husband not to discuss the case with your daughter. All that.
Yes.
And despite that order, you wrote emails to your daughter that were highly disrespectful of your ex-husband, didn't you?
I did have emails.
Well, the emails called your ex-husband disparaging names, didn't they?
Objection.
What's the basis? I mean, how is this relevant, Mr. Williamson?
For truthfulness, testifying here and in her case.
I'll let this go a little further, but it seems like to me we're sort of off base at this point. Go ahead.
All right. In any event, you were held in contempt of court on August 15, 2013 in that case, correct?
I believe so.
Among other things, okay. Now, during your divorce proceedings, you had two different lawyers represent you in the case.
Correct.
And both of those lawyers asked to withdraw from the case because you had trouble paying their bills.
No, sir.
Why did they withdraw?
Wiley Wooten's firm withdrew for that reason, but my second attorney, Constance Lowe, never withdrew from my case due to non-payment.
Well, then why did he withdraw?
Mr. Wooten did with his law firm, and then my second attorney was not with his law firm. It was a attorney Constance Lowe from Hillsborough, North Carolina.
Well, as a result, you had to do a substantial portion of that trial yourself, correct?
I only represented myself maybe one day.
trial took place over a number of days, correct?
Yes,
Total of 17 days.
that sounds correct.
Just beginning on January 2nd, 2013, ending on April 4, 2014.
Yes, sir.
That sound right?
Yes, it
I
does.
may not remember the exact dates. Now, the judge issued a final judgment on August 27, 2015. Is
Yes,
that right? You
yes.
recall that?
I believe that's correct.
And in that final judgment, the court made findings of fact as to the value of the entire marital estate.
They did.
And he valued that marital estate to be worth around $716,000. You recall that?
Yes,
And that was combined with your debts. And in the final judgment, he ruled that you owed your ex-husband about $25,000, right?
he did.
And anyway, he ordered you to pay that amount to your ex-husband,
He did.
and you consented to the entry of that judgment.
Yes,
And you signed the document and agreed to pay your ex-husband the $25,000.
and I believe they set it up as a monthly installment over 10 years.
Part of that debt was damaged to a 2011 Nissan Maxima in the amount of $1,600. You recall that?
I do.
And at the date of the separation, you and your ex-husband owned that Nissan Maxima, correct?
We did.
And you drove it after the separation.
Yes,
And prior to the final judgment, Judge Lambeth ordered you to return the vehicle to your husband.
yes,
And you returned it on February 25, 2013.
I believe that's correct.
And that vehicle had exterior and interior damage.
Yes,
And it appeared that the seats had been cut.
yes,
And there was damage to the interior wood that appeared to have been scratched.
that's correct.
And now you testified that it was damaged when you swerved to miss a deer and hit a tree at approximately 45 miles per hour several days earlier. That was your testimony.
That was the exterior of the vehicle.
You didn't report that accident to anyone.
Objection, Your Honor.
Overruled.
You didn't report that accident to anyone, did you?
No, sir.
You couldn't give it, Judge Lambeth, any explanation as to how the seats were damaged.
I did.
And in that judgment, Judge Lambeth made a finding that you had lied to the court.
That was his finding. Yes,
And what he specifically said was, the court finds that the plaintiff lied about how this damage was incurred, and that either she did it purposely or had it done purposely.
he said that. Yes,
Fine. And that was the basis for ordering you to pay $1,600 for damage to the Maxima.
I believe so.
Now, the judge also saw text messages exchanged between you and Dwayne Mims' wife, in which Mims' wife indicated that her husband would testify for the highest bidder, and where you indicated that she would be the highest bidder.
Yes, that's out of context, but yes.
Now, when you were asked about those text messages, you testified that you meant to indicate to Mims that you would help him get money back that your ex-husband allegedly owed.
He did owe him around $45,000.
So now the judge found that you had promised to pay Dwayne Mims money for him to testify falsely on your behalf regarding your ex.
No, I did not.
He found that, though, didn't he?
That's what he found. I guess if that's what you say. Yes, sir.
And he specifically said in the August 15, 2013 order that he did not believe your testimony.
That's what he said.
And after that, at one point, you were convicted of trespass at your ex-husband's new home,
Domestic trespassing, yes.
broke into his home after you were separated.
No, I did not.
Getting Mr. Megaro. Now, on September 21, 2015, you hired Megaro and his firm to represent you in appeal after the court issued the final judgment, correct?
Yes.
You put that first exhibit, the retainer agreement, I think it's number 1 that you had first exhibit back on the screen.
What number? What number?
Oh, it had 1 mark. Okay. It's the retainer agreement. Right. Scroll down a little bit. Next page. Yeah. Okay. Okay. Now, is that retainer agreement on your screen?
It is.
Would you please read for the panel what's in bold there, beginning with "please be advised"?
Would you like for me to start there?
Yes, just read that paragraph.
Okay.
Please be advised.
Please be advised that in connection with filing this appeal, you are responsible for covering the cost of the purchase of transcripts and minutes of all of the proceedings in the trial court, as well as the cost of appellant printing and copies and all filing fees imposed by the court. You hereby expressively agree to pay these costs and acknowledge that without the transcripts and minutes of the proceedings in this trial court, we cannot properly file this appeal and represent the client in this case.
And as we can see, that paragraph is in bold,
It is.
and you were aware of that at the time you signed it, correct?
Yes.
Okay, and that was something about costs and transcripts that you had discussed with Mr. Megaro before hiring.
Yes.
And now, pursuant to the terms of your judgment, you were required to start paying your husband the money you owed him on October 1, 2015.
Yes.
And that was less than 2 weeks after you hired Mr. Megaro.
Yes.
Now, prior to October 1, 2015, you had consulted with a bankruptcy attorney because you anticipated filing for bankruptcy.
I did.
And you were considering that so you could get out of paying your ex-husband the money the court had ordered you to pay.
I couldn't pay that every month.
Now, on October 1, 2015, you wrote in an email to Mr. Megaro saying that, quote, "the whole appeal may be in vain." All that?
I don't recall that exactly.
We could.
On display.
Yeah, we
You
need
gotta plug
to,
them
is
in.
it just one at a time? Can you? Yeah, we need the display.
Yeah,
Okay,
I prefer.
thank you.
I'm lost. What are we doing?
What?
What are we doing?
We're putting an exhibit 132 on the screen if we can figure out.
Thank you. I didn't hear that. So I was,
Sorry, both tables can display.
But you have to unplug, right? Or
I'm
something like that.
unplugged.
Okay.
Mr. Williams, to be clear, these are your exhibits.
These
so
are.
this would be in the book versus a digital. I mean,
Yeah,
I know
it's
you're
the-
displaying and I
It's the
understand that.
same as the hard copy.
Got it.
This particular exhibit is 132.
All right.
Do you have that in front of your screen?
I do.
If you would just read, Is that an email from you to Mr. Megaro dated October 1, 2015?
It is.
If you could just read that first paragraph, it's 3 lines. Patrick, I call. Just read that.
Patrick, I called my bankruptcy attorney, and she said if Jim has to pay me any money from ED, then he can claim bankruptcy, Chapter 13, and relinquish all debts to me. She said that the only way he could be forced to pay is if it's called alimony. The whole appeal may be in vain. This is not good news on my behalf. Let me know what you think. Thanks, Grace.
Thank you. So you did in fact write that email.
I did.
Okay, thanks. Now, come October 1, 2015, you did not make the first payment to your husband as required.
Not till the next day.
Well, on October 2nd, 2015, your ex-husband's lawyer filed a motion to hold you in contempt.
Yes, 24 hours.
He asked that the court hold you in the Alamance County Jail, correct?
Probably.
This is Exhibit 129, is that correct? Yes. And we, obviously the bolding is ours.
133, sorry.
What?
That's 133, 129.
133? Sorry. That's 133, the motion to compel. Now, on October 28, 2015, approximately 1 month before hiring Ms. Megaro, you did file a petition for bankruptcy in federal bankruptcy court.
Yes.
Okay. And now, on November 11, 2015, Mr. Megaro's paralegal sent you an email with an estimate for transcribing the dates of the trial. All that?
I'm not sure the exact date, but I think he gave me a ballpark.
Okay. Well, the estimate for the trial transcripts was $10,000.
Correct.
And of course, that's a lot of money, but there were 17 dates for your hearing, correct?
Correct.
Now, you forwarded that email to Mr. Megaro the next day on November 12th, and that's on the screen there at 136.
Yes.
Okay. Could you read for us that email? Starting, hey, Patrick.
Hi, Patrick. Received an email yesterday about the cost of the transcripts. I hope that is only the estimated cost for the entire trial. The transcripts need to only be transcribed for ED. I'm not sure how to do that, but there is no way I can pay $10,000 for that. But I had in my budget a couple of $1,000s, but that figure from the email is out of my reach. Please contact me today or have one of your assistants to discuss and explain this to me if I'm not on target here. Thanks so much, Grace.
Now, after that, you told Mr. Megaro's paralegal that you could find your own court reporter to do it for cheaper.
I said I would try.
Now, on November 18, 2015, you emailed Mr. Megaro and told him you had found Ruth Paulson, the court reporter who would prepare the transcripts for less.
Yes.
And we've got their defense number 137. Is that an email that you sent to Mr. Megaro on November 18, 2015?
Yes.
Could you read for the panel that email?
Patrick, the transcriber's name is Ruth Paulson in Arden, North Carolina. She's emailing you and I both a contract today. I am mailing her out the CD that covers January the 2nd, 2013 and March 19, 2015. She has asked that I give her $1,000 up front and remaining balance upon completion. That way she will not overcharge me. She has agreed to have it completed by the end of December. Let me know if you need me to do anything else to speed up the process.
Now, in fact, Ms. Paulson, court reporter that you had preferred to get rather than what Mr. Megaro would have lined up, did not prepare those transcripts until March 4th, 2016.
I don't remember the exact date.
You see there, 138 is an email from Ms. Paulson to Mr. Megaro, March 4, 2016, saying transcripts complete and listing all of those various volumes.
Yes,
So would you agree that she did not prepare those transcripts until March 4, 2016?
it took long because they're 2015 pages.
Now, after your appeal was dismissed, you asked Mr. Megaro to file a petition for a writ of certiorari in the Court of Appeals on your behalf,
He recommended that.
and he did file that petition for writ of certiorari after the appeal had been dismissed because the transcript had not been prepared in a timely way.
Yes,
And that petition is 140 on the screen there. You've seen that, I assume, at some point.
yes.
Okay. And I'm not going to ask you to look at the whole thing, but it's over 250 pages, that petition, correct?
I assume so.
Now, on September 12th, well, you knew your appeal had been dismissed because the transcript had not been prepared in a timely manner.
I knew only after this cert.
Now, on September 12, 2016, you emailed Mr. Megaro after you received a copy of the petition. Bring that up. And when you read that email,
The entire email?
well, yes, Patrick, and
Okay, Patrick, hope you're doing well. I've been out of town and returned this evening. The appeal package arrived and it was so impressive. I looked at the date, the Alamance finally signed off on it, and you must have really put the fuel under their butts because it was only days after you called to talk to them that it was made official. So what happens next? The Court of Appeals reviews our request to be allowed for an extension. And how long do you think it's going to take for them to make a decision? Just a ballpark idea? Also, is Dan going to be Jim's attorney? Patrick, I'd like to take this time to tell you how much I appreciate everything that you've done for me to even be able to get this far. If it weren't for you, all hopes of ever getting any justice would have been diminished long ago. I just keep praying that the appeal court judges see how a great injustice was dealt to me. I only wanted what I was entitled to, but instead all hopes were shattered by the one person that I trusted the most, and the one man that promised me that he would not let me down and he would not hang me out to dry. I think the day in court when he asked the judge to withdraw from my case was the day that I lost faith. I was crying so hard that I couldn't even speak on my own behalf. I begged God to take me out of this world, and somehow I tried to just hang on a little bit longer, even after many months of severe depression. You're the only person in the past 4 years that gave me your word and honored it to the end. I don't know why you have been so kind to me and so supportive, but I am forever grateful for you. I truly believe that God had it in his plan to somehow cross your path in this thing called life. Patrick, even if this does not fall in my favor, I give you my word and that I will repay you each month as long as it takes to settle my debt with you. Thank you for being my gentleman for justice. In best regards, I remain Grace Humphrey.
No further questions. Thank you.
Will there be further direct, Mr. Murphy?
Yes. Ms. Humphreys, did Mr. Megaro ever tell you that he could file an extension under Rule 7 to give more time to file the court reporter's contract or anything like that?
No, sir.
Did you know as a layperson that you could do that?
No, sir.
Who did you pay approximately $5,000 to preserve your right to appeal?
Mr. Megaro and his firm.
Did you know that the appellate rules required that if you didn't file, make a contract with the court reporter, then that you had to file the record on appeal within 35 days?
No, sir.
Did Mr. Megaro ever talk to you about filing an extension of time in the district court to extend the time for filing a record on appeal?
No, sir.
Did he ever tell you that he had filed a motion for extension of time to file the record on appeal in the Court of Appeals, and that the Court of Appeals rejected it and told him he could, without prejudice, to go back and file it in the trial court?
I was never told that information.
Does that cause you into question whether Mr. Megaro even knew the rules of appellate procedure?
At that point,
Overruled.
I can answer. At that point, I was beginning to wonder. That's why I was becoming so concerned.
Did you see in the transcript with Judge Lambert where he admitted he had violated 2 rules, and if you give him just some more time, could violate some more?
I did see that.
Have you, well, this goes to phase 2, if I can, a little bit, Your Honor.
Any objection, Mr. Williamson?
No.
Has your impression of the legal profession been diminished in any regard as a result of your relationship or your experience with Mr. Megaro?
Completely diminished.
Pardon?
Completely diminished. I have very little faith in the justice system from that.
Now, that last email we saw from that you wrote him, was that before you had a chance to talk to the Court of Appeals and learn what had happened with your petition for writ of certiorari?
Correct.
Did you understand that a petition for a writ of certiorari is a extraordinary writ and it's not a appeal of right? Or did you even understand that?
I didn't understand that. That's why in the email I called it an appeal packet. I didn't even understand the difference. I thought that was what you had to do in order to file an appeal.
All right, that's all the questions I have.
Further across, Mr. Williamson?
Just briefly, Mr. Murphy asked you a question about Rule 7, about whether Mr. Megaro had requested an extension.
Yes, he said that.
Okay. Did you know that he in fact did do that?
I did after the fact. I don't know how many months later, but
So he did move under, he did move under Rule 7 for an extension.
I'm not sure if he met the deadline for that.
Bottom line is, you knew it was your obligation to pay for the transcript. You knew that was necessary. Didn't do that. You took it upon yourself. You rejected his advice to get a court reporter who would prepare it timely. You found somebody who didn't do her job, and you want to hold my client responsible for that.
That's not correct.
Deny it. Fine. Nothing further.
Any further?
Yeah.
Mr. Morris, any questions? Mr. Bennett?
No question.
Thank you, Ms. Humphries. You may step down. Ms.
Thank
Humphries,
you.
we require the witnesses with the COVID rules to grab one of the wipes if there's somewhere around you, and please wipe down the microphone and
Yes, sir.
anything you may have touched while you were there. I'm sorry you have to do
Thank you.
that.
Your Honor, could she be released from this?
Yes, I have no objection to that.
Certainly.
Will there be further evidence for the state?
The state bar would call Mr. Mark Sneed.
Mr. Sneed, come around, please, sir, and place your left hand on the Bible. Raise your right hand and face the clerk. Mr. Sneed, does the testimony you're about to present, will you testify, will the testimony be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You may have a seat.
Sir, if you would, keep your voice up so we can all hear you, and tell us what your name is.
My name is Mark Sneed.
And Mr. Sneed, where do you live?
I live currently in Morrisville.
And how are you employed, sir?
I am currently a Special Deputy Attorney General with the North Carolina Department of Justice.
And how long have you been with the North Carolina Attorney General's office?
It will be 18 years this coming May.
Throughout your career in the North Carolina Attorney General's office, can you tell us what sections of the Attorney General's office you have worked in?
Certainly. I began there in 2003. I worked with the workers' compensation section, just defending workers' compensation claims before the Industrial Commission. Then I moved on to kind of act as agency counsel for the Industrial Commission. Still in.
I'm sorry, I didn't hear that last piece.
I was working as agency counsel for the Industrial Commission. And then that position got moved to services to state agencies. And then it got moved back to tort claims. And then I started doing tort claims themselves. And then in 2019, moved over to services to state agencies.
So you have practiced before the Industrial Commission for a good part of your career.
Most of my career.
And at one point you were actually the agency counsel
Yes, sir.
for the Industrial Commission. Does the benefit of the panel, does the Industrial Commission have jury trials, or is it just heard before a hearing officer?
They're generally bench trials before a deputy commissioner. So with both tort and comp, you appear before a deputy commissioner. It's a bench trial. After that, then any appeals are heard by the full commission, which is basically a three commissioner panel.
Were you in September of 2015, what section of the Attorney General's office were you working in?
That would have been the tort claim section.
Were you familiar with a proceeding in the Industrial Commission involving Leon Brown and Henry McCollum?
Yes, sir.
And were you the member of the Attorney General's office that represented the state of North Carolina in that proceeding?
Yes, sir.
Can you give the panel just a general idea of how you go about getting how you can go about getting a proceeding under North Carolina General Statute 148-84, which is the payment for compensation for wrongful convictions? How can one of those proceedings be initiated in the Industrial Commission?
So my understanding is that the claimant would file an affidavit with the Industrial Commission. It would be filed there. And once it's filed with the Industrial Commission, they would send it over to the Attorney General's office. The section head for tort claims would then assign that file to me. Within that file, we would see everything that was basically needed. We'd see the innocence petition. We would see the time that the inmate spent in prison. We'd have a printout of all those things, so we'd have it handy for the file.
If you have a pardon of innocence and you have a documentation of that, and you have documentation of a time you were spent in prison for that wrongful conviction for which you received a pardon of innocence, does it really come down to just some math computation?
It really does. So basically, when we get those files, it's just basically kind of a check the box kind of a thing. So what we're looking for first is, I think, the 182, the statute that's right above 184, it basically says that they have to plead not guilty at the initial trial phase. So we just look at the plea there to make sure that that box is checked. Then we have to see the pardon of innocence that's in there, which you just look at that. That's fairly easy. And then we've got a printout from DPS, which shows exactly how much time they spent imprisoned. And so the statute says $50,000 for every year that the person was improperly imprisoned. So at that point, you just kind of do the math, $50,000 for every year that they're imprisoned, and you prorate anything else. And you're also looking for basically to see whether they were in prison for any concurrent charges at that time. Because if they're in prison for concurrent charges, then you wouldn't get credit for the $50,000.
Under the statute, is there a maximum?
The maximum caps at $750,000.
Did you work with Mr. Megaro, the defendant in this case, on the action in the Industrial Commission filed by Mr. Brown and Mr. McCollum?
Oftentimes we will stipulate to documents, and typically I can go through that stuff in my office. It doesn't take a lot of time. A lot of times I will talk to opposing counsel, but that's not always. And in this particular case, I don't remember whether I spoke to Mr. Megaro or not.
Can you give the panel an idea how much time you had involved in this case before you went to the hearing in the Industrial Commission?
Sure, it's not a lot of time. Like I said, you're just basically checking the box. I could probably work up this case in 30 minutes to an hour.
Did the state of North Carolina, were you opposing the claims of Mr. Brown and Mr. McCollum?
No, sir. From what I recall in reviewing the transcript, everything was very straightforward. I think Mr. Megaro gave kind of a summary as to what was happening here. I agreed with him, and we basically stipulated to the fact that both Mr. McCollum and Mr. Brown were entitled to the full amount of $750,000 apiece.
Let me pull up. We have on the screen, and you should be able to see it over on your left.
Sure.
This is exhibit 632.
Yes, sir.
Let me refer you over to, do you recognize this as a transcript from the hearing in front of the Industrial Commission on September 2 of 2015?
Yes, sir.
And I'll refer you. On page 3, I believe there's where you told the court that, or the court finds that there was stipulated to the exhibits. So there was a stipulation to exhibits ahead of time?
Yes, sir. Oftentimes we may just kind of get together before we formally go on the record. We'll look at exhibits and we can go through it then.
And look at over on page 4, down at the bottom, will you just read what your statement to the court was at that time?
Yes, sir. Your Honor, the state is in agreement with everything that Mr. Megaro has said this morning. We've got a pardon of innocence from the governor from 2015. The terms of incarceration, I believe, are accurate. And from the state's standpoint, it looks as if both of these gentlemen are entitled to the full benefit as awarded by the statute, capped up to $750,000.
Anyways, that confirms it. It was unopposed and
Unopposed, really simple.
both were going to get the whole full 750,000. Could you refer to 32A? And if you look, do you see the what appears to be the checks as a result of the proceedings?
Yes, sir.
All right, and the total amount paid out for each of the claimants was $750,000.
Yes, sir.
Were you at the time this took place, were you aware of any fee arrangement that Mr. Megaro had with the Mr. Brown and Mr. McCollum?
No, sir. We'd never see that kind of information.
Does the Industrial Commission know about what type of fee arrangement there is between Mr. Megaro and the claimants?
That I'm not sure. I know in workers' compensation, they have to approve fee arrangements, tort claims. I'm not sure. And with these, I'm not quite sure what the approval process is for that.
Thank you, Mr. Sneed.
Certainly.
Will there be cross-examination? Mr. Williams?
Yes, no, not very long, but Mr. Sneed, I'm Lane Williamson. I represent Mr. Megaro in this proceeding. I wanted to ask you, do you recall you were not originally the attorney assigned to this matter?
I don't recall.
Okay, because the notice of hearing or whatever, Stacy
Stacy Meyer.
Meyer, I'm sorry.
Stacy Meyer would have been the section head at that point. And so what I'm pretty sure happened is when the Industrial Commission sends it over, they send it over to the section head. Stacy Meyer, as the section head, would assign the files to an attorney in the section, who would be me.
And do you recall when that assignment was actually made to you? When did you, in terms of when the actual hearing was, when did you find out, okay, this is my case?
I can't remember, but typically if Stacy's going to assign something, she gives me plenty of time to look through it. I would say probably more than a week or two.
But you don't recall ever communicating prior to actually going through the hearing with Mr. Megaro?
I don't. I may have, but I don't remember if I did or not.
If you were to testify that you didn't, you wouldn't have any reason to question.
I would not.
And when you went into the hearing, do you recall Mr. Megaro was already there when you were?
I believe that's correct.
He'd come prepared with a large amount of documentation.
I believe that's correct as well.
And he had, as far as you know, had not been told that this was essentially going to be a stipulated result.
I can't speak to what he was told.
In any event, you hadn't told him, and you were the attorney. And
I don't remember what I told him or what I
Okay.
didn't tell him.
fair enough. A while back. Now, was this specific proceeding does require as a precondition that there be a pardon of innocence? Correct?
Yes, sir. That's correct.
And prior to this hearing, had you handled other proceedings where there had been a pardon of innocence and an award?
Yes, sir. I handled other erroneous conviction cases as well.
There had not been any under the LaCroix administration brought to your attention for this.
I can't recall.
And you have no idea, no reason to know what all work that Mr. Megaro did in connection with obtaining the pardon of innocence from the government.
That's correct. We don't have any knowledge of that before it gets to the
Not your
I'm sorry,
Not your concern, correct?
correct.
One moment. I believe that's all.
Further redirect.
No, none, Your Honor.
Mr. Morris? Bennett, any questions?
No.
Thank you, Mr. Sneed. You may step down. Any objection to him being released from a subpoena?
Not at all.
All right, thank you, Mr. Sneed. Mr. Sneed, we require all our witnesses to wipe down the witness chair and so on. Sorry you have to do that, but that's the time, the day of the times, I guess.
It's no problem. I don't mind at all.
All right, thank you, sir. Will there be further evidence for the state?
There will, State Bar, State Bar called Dr. George Corbin,
Dr. Corbin? There,
Corbin. You come around, Dr. Corbin.
Dr. Corbin, sir, if you would raise your right hand, place your left hand on the Bible. Do you solemnly swear or affirm the testimony you're about to provide to the court to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, sir, please have a seat.
You can take that off, Dr. Corbin.
Thank you.
If you would, sir, tell us what your name is and where you live, just generally, not the specific street address.
Sure. My name is George Patrick Corvin, MD. My last name is spelled Corvin. I'm a general and forensic psychiatrist, and I live in Raleigh, North Carolina.
Do you, what's your current employment?
I'm senior partner at North Raleigh Psychiatry, which is a practice in Raleigh, North Carolina, where I'm actively engaged in the full-time practice of general and forensic psychiatry.
What, for the benefit of the panel, what is forensic psychiatry?
So forensic psychiatry, most broadly put, is simply the area of psychiatric practice that interfaces with issues of law or questions that become before a trier of fact in some sort of a judicial or court setting. There are a lot of different subsets of work within forensic psychiatry, for example, capacity, criminal responsibility, personal injury, professional standards as a psychiatrist, things of that nature. The body of data and experience, if you will, that you use as a forensic psychiatrist is very much the same that I use when I'm treating patients in my office. It's just for a very different purpose. Instead of clinically, where I'm trying to get somebody better, in a forensic setting, it's universally the case that I'm offering information to a trier of fact to hopefully assist them in making decisions that involve sort of specialized knowledge, in this case, specialized knowledge in the field of psychiatry.
Could you tell the panel what your training is, you know, where you went to school, got you, and where you went to medical school? Please?
Yes, sir. So I completed my undergraduate education at a small school in Alabama, Birmingham Southern College, graduated from there with degrees in biology and psychology. I then attended the University of Alabama School of Medicine and got my medical degree, after which I then attended the Medical College of Georgia in Augusta, Georgia, where I completed a 4-year training program as a general psychiatrist. And I spent my last year there as chief resident for MCG in Augusta. At that point, I became board eligible and subsequently board certified as a general psychiatrist, but I decided I had become interested in the interface, if you will, of psychiatric medicine with the law. And so I decided to pursue what's called a fellowship, which is sort of a specialized period of training after a general residency, a fellowship in forensic psychiatry, which is what brought me to North Carolina. Originally, I applied to and was granted a position with the Department of Justice in their fellowship training program, which had me working during that time primarily for the Federal Correctional Complex in Butner, North Carolina, where there is one of the 3 large federal referral centers for forensic evaluations in the United States. Since that time, I've maintained board certification in both general and forensic psychiatry. And as noted earlier, I've been involved in clinical and forensic practice ever since.
You are board certified?
That's right. For 20 or so years, I was certified with the American Board of Medical Specialties. And for the last 4 or 5, maybe going on 6 years now, I've been certified through the National Board of Physicians and Surgeons.
In addition to your fellowship with the Department of Justice, what other practical or experience did you have in the actual practice of psychiatry?
So over the last roughly quarter century, my forensic practice is primarily, but not entirely, centered in various aspects of criminal forensic practice. During those years, both in this state, in federal court, and numerous other states around the United States have offered testimony and completed evaluations in criminal matters, both for defense attorneys and for prosecuting attorneys. More so in North Carolina because of the way it's structurally built, if you will. It's been primarily defense-oriented criminal work. Probably about a quarter of my practice is involved civil area of practice, which would be like I mentioned before, personal injury matters, professional standards or standard of care issues, boundary violations in professional practice, things of that nature. But over the course of that 25 plus years, I have testified in various courts well in excess of 300 times.
And you've been qualified as an expert to give your opinion on the forensic psychology issue?
On each of those occasions, yes.
I would tenure Dr. Corbin as an expert in the area of forensic psychiatry.
Any objection, Mr. Williams? All right, you're accepted as an expert in that area. Thank you, doctor.
Thank you.
Dr. Corbin, do you conduct an evaluation of Henry McCollum in 2017?
I did. He was actually evaluated on August 22nd of that year. Yes.
And how did you become interested in that matter?
So I was contacted not long before the date of that evaluation by an attorney, Tarleton, I believe, and Raymond Tarleton. And as I understand, I wasn't involved at this point, but as I understand it, a federal judge, because of litigation that was going on in federal court in the Eastern District of North Carolina, had requested that an evaluation of Mr. McCollum's capacity, a particular form of capacity, be undertaken. As I understand it, names were submitted, and ultimately it was requested by the court that I complete that evaluation.
And was there an order entered by Judge Boyle, to your recollection, that for you to conduct that an evaluation of Mr. McCollum?
So according to my records, on August 14th of that year, Judge Terrence Boyle did file such an order. Yes.
And did you conduct a evaluation of Mr. McCollum, and did you in fact produce a report based on Judge Boyle's order?
I did.
Would you tell the panel, well, let me back up a second. Let me show you what, and there'll be a panel right there to your left. Safe Bar Exhibit 657. We can scroll through that if you need to.
And I have a copy of it as well. So
You do.
I do.
Do you recognize this, the Exhibit 657, as a copy of, well, sure. Yeah, as a copy of your report pursuant to Judge Boyle's order?
That is correct. Yes, it is.
And if you would tell the panel did you actually meet with Mr. McCollum?
I did. I met with him for approximately 2 hours and 20 minutes on August 22nd of that year at my office in Raleigh, North Carolina. That was far from the only aspect of that evaluation, but I did have a face-to-face evaluation with him.
Okay. When, and so you got a chance to talk to him for that period of time. Did you consult other sources of information?
Many other sources of information, yes.
And are those listed in your report to the federal court?
There are, in terms of collateral records, that report, the one dated September 9, I think, on the top of it is had 24 sources of information in addition to my interview with Mr. McCollum.
And is the type information listed in your report the type of information reasonably relied upon by experts in your field in conducting evaluations of individuals?
Oh, yes, yes.
Okay. And did you, in the course of your evaluation, did you obtain some background information on Mr. McCollum?
A considerable amount of background information, given that, oh, I'm sorry.
Can you summarize some of that you put in your report?
Yeah, so as you can imagine, for Mr. McCollum, who had been in custody for 30 plus years and who had a pre-existing known history of some mental health difficulties, which we haven't discussed yet, you can imagine that over the course of those years and the lengthy litigation related to Mr. McCollum's case that predated my involvement in the case, he had already been examined by numerous mental health professionals. As such, there was perhaps more so than is typically the case in matters of forensic nature like this. There was a very extensive volume of not just developmental records, but mental health evaluation records. And, you know, when you take, as a forensic psychiatrist, part of what we do is when we have literally records that number into the thousands of pages of records, what we're looking for is a pattern in the chaos, if you will, a pattern that makes sense clinically that can be applied then to a forensic question. I've gone far afield from your original question, but the source of information that was available were interviews with counsel who had known Mr. McCollum over the years, interviews with psychologists who had evaluated Mr. McCollum over the years, reports of psychological evaluations of individuals who had evaluated him prior to me knowing who he was. Reports of psychodiagnostic testing, and in particular, neuropsychological and intellectual testing that had been done far before I became involved in this matter. And then, of course, there was, along with those clinical records and those clinical interviews, a plethora, I guess you could say, of documents summarizing the legal history of Mr. McCollum's case. For example, a motion for appropriate relief that had a procedural history, if you will, that sort of helped me put together, okay, this is what's happened with Mr. McCollum in court, but this is what this bevy of mental health professionals has been saying during that time as well.
In your interview with Mr. McCollum, did you gather some background information from him? And I'm referring over to page 5 of your report.
I did. I think it's worth saying that Mr. McCollum was not thrilled about being asked to see me at all. He was not thrilled at the prospect of his capacity being questioned. I don't think he still is, to be honest with you. But he was cooperative, and he did provide information regarding what we call his psychosocial history, his biopsychosocial history, that was useful. And it's summarized in that report.
Was this interview with him recorded?
So it was at his request. Mr. McCollum clearly did not trust the process at this point. And, you know, given what has happened to him over the years, I think it's understandable that he would have some trepidation about this. But for the most part, what I'm struck by with Mr. McCollum is he has he's greatly unhappy at any suggestion that he's slow or his word retarded or intellectually disabled or that he needs help or things of that nature. He's never really, and I don't blame him, but he's never really rejoiced in that prospect, if you will. And so at his request, the interview was recorded.
Did he tell you about an event happened when he was 9 in terms of a rape?
He did. When he was 9 years of age, he was, I guess, working bagging groceries at a local grocery store where he lived. And he was not, I mean, he was 9, and he was with an individual bringing his groceries up to his place, I think. And what he described happening is that he just basically was hit in the back of the head, knocked out, and that when he woke up, he had been sexually assaulted. And the individual, when he woke up, sort of threatened him and told him that he liked it and hit him again or something of that nature. But he was basically physically and sexually assaulted.
Did he tell you, quote, "I was 9, I trusted him, I didn't see the warning signs"?
That is correct.
You've got that in quotes, so that's directly from him.
That's quote from him, yes.
Did he tell you about another incident of a head injury where he ran into I believe a dumpster?
Right. When he was 6 years of age, I don't think he knows this from his personal knowledge because he was unconscious, but he ran headlong into a dumpster and experienced, not his words, but what's described as brief loss of consciousness.
Did he also describe for you the time he had spent on death row?
Yes, he did.
Tell him about some of that information.
So this will probably come as no shock to anybody here, but Mr. McCollum's time on death row was horrendous. It was horrific. It is so, I mean, I spend a lot of time evaluating other individuals on death row. And as you can imagine, it is a somber, depressing, dreary place by definition, by its very nature. But if you can imagine the prospect of being, and I'm describing what he described to me, but in my own words instead of his words, the prospect of being on death row for 30 years, seeing dozens of what he described as his quote family put to death, all while knowing that he did not commit a crime. And the effect of that, as you can imagine, has left a mark on Mr. McCollum that continues to this day. When I most recently spoke with him, he continues to experience a range of symptoms that are classic for post-traumatic stress disorder: hypervigilance, nightmares. He'll wake up thinking that he's still in central prison on death row, nightmares of actually being executed. And don't get me wrong, my interaction with people who spent many, many years on death row, none of them are enjoying that experience. But for someone who has the pre-existing inherent limitations that Mr. McCollum has, and at the same time knowing that you didn't do anything, it's just, if there's such a thing as rubbing salt in the wound of being on death row, that would be the thing that would do it. He at the same time, though, has said that he believes that being on death row made him stronger in some respects. And as a psychiatrist, I don't necessarily disagree with that in some way. His focus on what he wants with his life now is very well defined. He knows what he wants to do with the rest of his life. And he has not, in particular, he's not consumed by anger and hatred over what's happened to him, which he attributes to his strong Christian faith. And I'm again off of your question, but my view as a psychiatrist in a nutshell is that, as you can imagine, being on death row under those circumstances for 30 plus years has indelibly changed him and he will likely be changed by that experience for the rest of his life in ways that are mostly negative.
Did you conducted a mental status examination? Did you you perform any testing with Mr. McCollum in the September 2017 evaluation?
Well, as a psychiatrist, I don't typically administer neuropsychological or intellectual testing. But both in review of his past records and my own evaluation of him, there was a particular neuropsychological deficit noted, and that had been noted previously by an examiner, more than one examiner, of impaired, what we call frontal lobe or executive functioning. And in that, I mean that Mr. McCollum, historically, above and beyond any impact of his pre-existing intellectual developmental disorder, what we used to call mental retardation, has a degree of impulsivity and a relative deficit in his skill to perceive and benefit from sort of recognizing the subtleties in interpersonal affairs. People have described him as being childlike, and in some respects I agree with that. In other respects I don't agree with that, which we may get into. But in terms of his frontal lobe functioning, he very much is a child in some respects. While he knows specifically what he wants for his life, to this day, he is very easily led astray, if you will. He's very easily persuaded of certain things. He makes decisions about how to interact with people that is, well, childlike. He may decide that an individual is a good person and has their best interest at heart simply because they are nice to them, even in contradiction to other evidence suggesting maybe the contrary. And so what I did do, this is back to your original question, is while I didn't do any what I would call formal testing, nor do I have the training to do such testing, I was aware of that testing having been done in the past. I am aware, as I was then, of the fact that neurocognitive disorders and intellectual developmental disorders are static. They don't improve in a manner over many years like this. But as a way of demonstrating those executive functioning deficits, I administered what is called the MoCA, or the Montreal Cognitive Assessment, which is more just a screening tool for neuropsychological impairment. And as I would have anticipated, based on what I had read already in my interactions with him, Mr. McCollum's performance on areas of that screening instrument designed to test frontal or executive functioning, sort of prioritization, following instructions, impulse control, being able to focus on one set of data and ignoring another set of data. Those are the sorts of skills that our frontal lobes help us with. And he did not do well on those. And so I actually copied those instruments simply not in a method of suggesting that he had these deficits, but rather as a demonstration of those deficits, which were known to exist before I knew Mr. McCollum.
Collateral interviews. Did you do some collateral interviews as part of your 2017 evaluation?
I did. I know I spoke with Mr. I think it's Kenneth Rose, who's an attorney. I spoke with Claudia Coleman, who is a forensic psychologist who I know well. And then Richard Rumer, who did another forensic psychological evaluation, who is somebody I don't personally know very well. So.
And did Mr. Rumer or Dr. Rumer recall Mr. McCollum and give you a lot of information about him?
He recalled him in very specific detail.
Let me ask you about your diagnostic impressions. We've talked, I think you've talked about intellectual development of Mr. McCollum. Explain to the panel, if you would, what intellectual development disorder is.
So intellectual developmental disorder used to be termed mental retardation. That is a term that is no longer used clinically. It is it is what it sounds to be. It is an acquired, if you will, it is a lifelong situation, if you will, or condition in which individuals suffer from sub-average or subnormal global intellectual capacity. The diagnosis is comprised of essentially two primary components. One is a subnormal intellectual testing battery. And I'm going to simplify and generalize this a little bit, but generally with IQs falling below 70, there are ranges of intellectual developmental disorder that are based in part on this, how far below 70 someone performs on intellectual assessment. The other main component of intellectual developmental disorder is the presence of a specific set or severity of adaptive functioning deficits. So one undertakes an assessment of an individual's ability to function academically, to function interpersonally, to take care of their own needs, to make use of community resources, to manage their finances, and there are many others. And what you see is that sort of in a, I'll call it a dose-dependent fashion, that individuals with IDD experience difficulties in those areas of self-care, right? And that as the degree of intellectual incapacity increases, so does the degree of inability in those areas of adaptive functioning. For many years, Mr. McCollum over the years has been intellectually tested on numerous occasions with scores that, well, this is not uncommon. There was some scatter with his scores. He has scored as low as in the upper 50s on an intellectual assessment, which is, in my view, probably not where he generally functions. He has scored slightly over 70 on at least one occasion I'm aware of that, well, the examiner said that it might be due to practice effect. So if you retest individuals in this manner, their scores can increase due to well practice. His scores, though, remember I mentioned a little bit ago that part of what I do as a forensic psychiatrist is look for patterns in the chaos. And if you bell curve his scores, his IQ scores fall in the mid to upper 60s. And based on my training and experience, assessment of his adaptive functioning abilities falls very much in line with someone whose intellectual testing falls in the mid to upper 60s. And that would equate with an intellectual developmental disorder of mild severity.
So is it true that from your examination of the records available on Mr. McCollum, we have IQ scores going back to the time he's 12 years old?
And decades. And I should say this, the very fact of testing in that for somebody to have that many tests of their intelligence, most of us don't. So above and beyond any diagnosis you put on it, there's clearly, and it's a clear indication that people were concerned about his intellectual functioning or academic functioning from pretty early age.
I think you also talked about the adaptive functioning, that being a component of your diagnosis of IDD.
That's correct.
What areas of adaptive functioning did you find he had deficits in?
So Mr. McCollum, well, most of them to some extent. Mr. McCollum, in part due to his inherent IDD and in part due to his, what we'll say, hypofrontal functioning, is an individual who is very prone to, you can convince him of things that most of us might question, right? And so clearly academically, Mr. McCollum has long struggled. When I most recently spoke with him, he had continued to, well, when I first spoke with Mr. McCollum, he was working on getting his driver license and had been unable to do so. And when I spoke with him in January of this year, he was still actively working on obtaining that driver license. So utilizing learning and being able to then use information that you previously learned in a way that's productive, as evidenced by an inability to pass a driver's test, is evidence, if you will, of an academic struggle. Mr. McCollum, although he does not believe that this needs to be the case, has a payee for income that he has available to him currently. He has difficulties and has in the past demonstrated difficulties in managing his finances. Mr. McCollum's ability to, shall we say, access services and interact and gauge interpersonal relationships is marked by a degree of impulsivity that most adults do not have, and thus it leaves him vulnerable to being led astray or misused. And so, as the Diagnostic and Statistical Manual itself states, Mr. McCollum can, in many respects, function independently, but in other important areas of his life requires some assistance. That does not say that he can't have a meaningful, productive existence, but even in terms of occupational functioning, it has been a struggle for him. And as the DSM states, occupational activities that individuals with this sort of intellectual developmental disorder possess tend to focus on repetitive tasks that don't require much in the way of abstract thinking, prioritization. It's simply the sorts of jobs where you put peg A into slot this and that, and so that their ability to sort of go above and beyond simple instructions can be problematic, and it is for Mr. McCollum.
You talked about his unspecified neurocognitive disorder, the frontal lobe executive functioning. Is that documented by other mental health examiners or psychiatrists in his records?
It is. I believe that Dr. Rumor was one of the individuals, but not the only individual who talked about him having neurocognitive deficits that are not accounted for by his intellectual developmental disorder. And I will tell you, even though we haven't discussed my opinions in this, that frontal lobe dysfunction that has been repeatedly examined is as contributory, just made up a word, I think, to his, what I would view as the impact on his capacity as defined by North Carolina law as anything that I've seen in Mr. McCollum. In that, let me take a step back. Over the course of my career, I have seen a number of adults who have in fact been declared incompetent before I saw them, who had frontal lobe injuries, but were otherwise generally intact, normal intellectual capacity. Because individuals with frontal lobe or executive functioning deficits can engage in impulsive decisions and lack the ability to perceive some of the subtleties in formalizing arrangements and relationships with individuals that is similar to a younger child. And remember, I said that Mr. McCollum, I would react negatively to him if I said that Mr. McCollum behaves and is like a child. But in some narrow areas, that is exactly the case. A young child, a 9-year-old child, might conclude that a man he doesn't know is nice and follow him to his apartment because the man smiled at him and gave him candy. None of us would do that. It would not be unusual for a 9-year-old to do that. It would not be unusual for Mr. McCollum, while it may be hyperbolic in a sense. Mr. McCollum's judgment on an interpersonal setting is similarly afflicted, so that he, while he has very specific and I think appropriate goals for his life, the means by which he would get there will require some assistance on his part, because he doesn't gauge those relationships with others in the fully developed adult way that we do. It's difficult to describe in a sense. So.
Dr. Carvin, let's stop there. Let's take about a 10-minute break for this morning break. And it's now almost 10:35. Let's try to pick back up about 10:45 if we can, knowing that we're going to stop at noon today.
There is a restroom around the corner. Dr. Corbin, back on the intellectual development disorder briefly, that I think you referred to that as being a static condition.
That's correct. So while it is the case that individuals with IDD, I'll just use that as a shortcut for that. Individuals with IDD can develop with assistance means to sort of deal with or compensate for some of the deficits that they have in the sort of conceptual, social, practical domains, right? So, but the flip side of that is that if someone has an intellectual developmental disorder, there is not a medication, there is not a treatment, there is not anything available to mental health or the field of medicine that will reverse, that will inherently increase the truly innate intellectual capacity of an individual with an IDD. And so what you're left with essentially are developing the supports and the degrees of assistance that these individuals need that will then enable them to function at their fullest capacity, right? But the condition itself is static. It does not go away. That is not how it is understood.
Well, a person can, I guess, develop coping mechanisms to make the condition less or something they can function with. How would the fact that an individual like Mr. McCollum spent 31 years on death row be any benefit to helping that?
So, obviously not. I mean, excuse me for saying that, but obviously not. So, an environment of incarceration on death row is an environment in which virtually every decision is made for you. Your life is controlled by a rigid and somewhat inflexible schedule. The range of interactions and social stimulation and interpersonal stimulation that you encounter is far.
Excuse me, Mr. Megaro is indicating he's having trouble hearing. Yeah, that's good.
I forgot.
Dr. Corbin also is a little closer to the microphone, please.
Sure, can do. I seldom get accused of speaking too quietly, but it can happen. So I'll put it this way: being on death row under any circumstances is it's a situation in which a person doesn't have to make a lot of decisions for themselves. They're not allowed to. It's a situation in which the sort of stimulation neurocognitively and psychologically that you're exposed to is very limited and or damaging. And thus, one would certainly not expect that an individual who entered incarceration as a late adolescent, 18, 19, I believe, years of age, who had a pre-existing intellectual incapacity would in any way benefit from those years of incarceration. Rather, those years of incarceration would entrench and perhaps in some respects make it more difficult for them to, as an adult, adapt to the sudden reintroduction into society at large, which is about as different from death row as you could possibly imagine. So.
And Mr. McCollum's diagnosis of IDD, also formerly known as mental retardation, is long-standing.
It is perceived as having an onset prior to age 18. It is, in his case, been present and observable for many decades, the great majority of his life. The source or sources of that intellectual capacity may be multifactorial. It may in part be a heritable condition. His half-brothers also struggles. It may in part be an acquired condition due to neurocognitive deficits from repeated blows to the head. Those sorts of things we'll probably never know with medical certainty. What can be known with, I think, strong medical certainty is that regardless of the cause or causes of it, he has this intellectual incapacity and has a many-year history of demonstrated difficulties in those domains that we were talking about.
We've discussed the frontal lobe issues, post-traumatic stress disorder. What's responsible for that, or is according to your evaluation?
Well, I think there's elements from earlier evaluations suggesting that his post-traumatic reaction, if you will, began at a young age when he was sexually and physically assaulted, as one might expect. that would place anybody at risk for acquiring a post-traumatic sort of view of the world, if you will. That experience, coupled with his other limitations, would similarly make him much more prone to the acquisition of an entirely different sort of source of post-traumatic stress, stemming from his years on death row. And his description of those years, it was emotional. The recording and my sort of description of it really does not do justice to the fact that he struggled to not tear up when I first spoke with him about this, when he spoke about people being taken to the death chamber that he described as his family, knowing that everybody, the fine citizenry of North Carolina, wanted to do the same thing to him, even though he knew he had not done anything. That in and of itself obviously would place someone with his background at risk of having persistent nightmares of being in that setting, dreams of actually being executed, still waking up thinking that he is in Central Prison's death row, extensively pacing during the day, as is often the case with long-term inmates, being fearful of seeing law enforcement in the community for fear that he will be wrongly accused, almost to the degree of phobic reaction to law enforcement.
Did you render an opinion on behalf of the or at the request of the court in your 2017 evaluation?
I did.
What did you find in terms of Mr. McCollum's practical ability to manage his own affairs?
Okay, so the question that was placed by Judge Bull was, in fact, does Mr. McCollum have the practical ability to manage his own affairs? And to inform my opinion, I utilized the language of NCGS 35A 11017, which I'm sure y'all know, so I won't quote it. My opinion at that time was that due to the combined influence of the conditions that we've been discussing, Mr. McCollum's specific disability, if you will, or vulnerabilities impacted his ability to manage his own affairs appropriately, and that due to the observation that this inability to manage his own affairs, including the ability to communicate important decisions about his person and property, given that that was due to, in my opinion, a direct result of his underlying illness, then it was my opinion that he lacked that capacity, as asked by Judge Boyle and as noted in North Carolina law.
And were you called to testify regarding your findings in federal court?
In federal court, yes.
And you essentially gave that testimony in court based on your evaluation of Mr. McCollum.
That's correct.
Were you contacted by me at some point requesting that you do a follow-up evaluation of Mr. McCollum?
That is correct. I believe I was initially contacted by you on December 3rd, perhaps of last year, or thereabouts.
And what were you requested? What was the request that the State Bar made of you with respect to Mr. McCollum?
So the request was very similar. It was a request to perform an assessment of Mr. McCollum's capacity, and I'll discuss what I mean by that in a second, with relation to some specific activities. Those activities were whether he had the ability, the capacity to enter into an agreement. I'm reading from my report on this, for legal representation with attorney Patrick Megaro on February 27, 2015, and then separately determination of whether he maintained or possessed the capacity to competently enter into loan agreements with Multifunding Inc. on March 4, 2015, March 11, 2016, and October 27, 2016. And in terms of framework for that determination, I again utilize the language of NCGS 35A 11017.
And does that language describe the standard or it's the definition of a incompetent adult in North Carolina?
That's correct. And just to make sure we're all on the same page, but I'm sure we are, it says specifically that incapacity or an incompetent adult is defined as an adult or emancipated minor who lacks sufficient capacity to manage the adult's own affairs or to make or communicate important decisions regarding the adult's person, family, or property. And then it continues, whether the lack of capacity is due to mental illness, intellectual disability, epilepsy, cerebral palsy, autism, inebriety, senility, disease, injury, or similar cause or condition.
And do you agree to do the evaluation for the North Carolina State Bar?
I did.
And you're being compensated for your work here and not work on this case?
That's my understanding, yes.
In conducting your evaluation, did you consult with and rely on the information that we've talked about earlier this morning, the information you had available to you from the 2017 evaluation you did?
That is correct.
All right. In addition, did you interview Mr. McCollum again?
I did. I saw him by video conference on January 29, 2021.
Okay. And how long did that video conference go with him?
That was about an hour and 15 minutes on that date.
Yeah. And what was the purpose of that interview with him?
Essentially, it had multiple purposes. One, I wanted to update sort of how he has adapted back into society, update again sort of his functioning ability and what kinds of assistance or outside supports he's receiving currently, to get a feel for his current mental status examination, and to inquire sort of his line of thought or reasoning about those issues we were just discussing, his relationship with attorney Megaro and his request or the entry into those loan agreements. And
what was his attitude towards you at that during this evaluation?
So at first he didn't remember seeing me before, which that actually caught me a little off guard, but my hair is a different color than it was perhaps then. He was, but he was appropriate with me. Now, that being said, he made no bones about the fact that he had been quite angry about myself or anybody else describing him in those various terms, slow or retarded, which I don't describe him as retarded, but and as has been the case on earlier examinations, really wanted to impress upon me how well he's doing. And for example, the idea that he's not bitter about what was done to him because of his faith, his plans to get married, that he wants to move on from this case. He wants this to be done and have his life and be able to live the rest of his life. I think he's 56 now, without having to think about this all the time. I don't blame him for that. There's a term in forensics, or excuse me, clinical psychology or psychiatry called the veil of competence, which is this: individuals who are aware of being tagged, if you will, as slow or limited will more or less always attempt to lead with, put their best foot forward. And that's almost universally the case, right? And that's fine. But I will tell you that the results of that evaluation in January revealed just as conclusive evidence of his static, if you will, his permanent sort of functional impairments in the domains that we've talked about. And so, I mean, as an example, during the interaction with him in January, Mr. McCollum complained about the fact that he has a payee or a supervisor of his funds, I don't know what the right term is, and insisted that he does not need that. If you look at, however, the sort of practical domain description from the DSM of individuals with his degree of IDD, it actually says, that these individuals generally need support to make healthcare decisions, legal decisions, to learn to perform a skilled vocation. Their understanding of risk in social situations is sort of immature. They're at risk of being gullible. They tend to approach problems in a concrete, sort of immature way. And as such, what part of the problem with Mr. McCollum is that while he has these limitations, he's convinced that he does not, or he certainly does not want us to see him in that way. And again, I think that's more commonly the case than not. But nonetheless, I would have been very shocked if Mr. McCollum presented in a way devoid of those indicators of intellectual incapacity, given that, I mean, that would be something I would want to write up, given that these individuals, while they can learn to function with support, they still need the support. They still need those sort of tools to protect them from being manipulated, to protect them from buying or signing agreements that they really don't understand, and things of that nature, because they'll do so without thinking. And given Mr. McCollum's frontal lobe deficits, that sort of compounds the problem, because he will react and make decisions about people without the ability to contemplate the subtleties of those decisions.
Did you talk to him about his contract for services with Mr. Megaro and why he did that?
I did.
What did he tell you about that?
Well, he decided that Mr. Megaro was nice to him, and Mr. Megaro gave him money, and from that determination, that led Mr. McCollum to conclude that he could unquestioningly trust Mr. Megaro, and that Mr. Megaro would only act to help him because he was nice to him. And I think the term he used was nice to him and had given him money at Christmas. And I think another attorney with the firm had given him some money at Christmas. And that led Mr. McCollum to conclude in a way that he would not surrender for some time, that he could unquestioningly trust them, that he could unquestioningly accept any recommendations that they made. And he continued to have that sort of attitude or belief. He said, even when members of his family started, he said they saw the problems before I did. Well, it goes a little bit beyond that. They saw the quote problems, or they perceived there being problems in the relationship, and he rejected their suggestion that there could be problems because he had decided that he could unquestionably trust them, which is one of the things you'll see in individuals with frontal lobe deficits, is that they can't surrender. They come to a conclusion impulsively, and they're stuck. They have difficulty realizing a mistake has been made or accepting it, if you will. So.
Did he have any sense or discuss with you about how much money Mr. Megaro was going to be getting, whether he understood that or knew about that?
Well, he said that he did not know how much money they were supposed to get, but he describes it in a way that a child might. They're good. I don't need to worry about it. Full speed ahead. You know.
Your diagnostic impressions, were they the same from your 2017 evaluation of Mr. Mr. McCollum?
They are the same.
Okay. That he continues to suffer from IDD?
Correct.
And that he continues to have the frontal lobal executive functioning impairment?
That's correct.
And that he continues to suffer from post-traumatic stress disorder?
That is correct. And on that subject, I should say it's extremely improbable that those first two diagnoses will change. It is at least possible that he may ultimately come not to meet full diagnostic criteria for PTSD, but at this point he still does.
And can you give us some examples of why you would diagnose him with still suffering from PTSD?
Sure. So I might have mentioned this already, but when I spoke with him in January, he continues to experience difficulties with hypervigilance, avoidant behaviors of situations that trigger a strong emotional reaction, i.e. law enforcement, nightmares, to some degree, almost flashback or dissociative experiences when he sees law enforcement in the community, waking up in a confused state, thinking he's still in the prison on death row. Those are all they fall into categories of symptoms for post-traumatic stress disorder.
Did you form an opinion to a reasonable degree of medical certainty based on your evaluation of him both in 2017 and then also your evaluation of him more recently as to whether he met the criteria of an incompetent adult at the time he signed the legal services agreement with Mr. Megaro, and at the time he took on these 3 loans that you were asked to focus in on?
I did arrive at such opinions.
What is your opinion?
That at all of the times that you just commented on, that the effects of his illness rendered him as an incompetent adult as defined by North Carolina law. And a retrospective assessment of this sort is sometimes difficult. It's always difficult, right? Determining an individual's competence years ago is by definition harder than it would be to do today. That being said, in Mr. McCollum's case, that assessment is made a little less difficult, given that the source of his incapacity is understood to be the result of conditions that don't get better, that don't go away, that once they're there, they are there. So if I break my arm and get an x-ray and there's a broken arm there, I might get that x-ray 2 months later and maybe it's healed, maybe it's not if it wasn't set right. So you need to check. But if the arm's cut off, I don't need to check again. And at the risk of sounding hyperbolic, that's what we're discussing when we talk about actual organic brain injury and an inherent intellectual disability. These are well understood to be permanent conditions. Not to go too far afield, in the Landmark Atkins decision, an argument was made subsequent in the progeny of that case that the individual's intellectual disability had been fixed. That was not received well clinically or legally because of what I just said. There are certain things that we just can't fix. We can work around it. So, for example, when you look at the actual descriptions of the difficulties these people have, it repeatedly talks about support is typically needed to, for example, raise a family. Support is needed in making legal decisions. Support is needed in making healthcare decisions. But with that support, appropriate support, they can get by.
Thank you. Just one moment, Your Honor. Let me refer you, Dr. Corvin, back to your first evaluation, which is Exhibit 657. Do you see down at the front of that first page of the report that the examination was as a result of an order entered by the federal court on August 14 of 2017?
Yes, sir.
Page 1. Down at the bottom.
Got it.
You know Dr. Harbin?
Yeah, I mean, not very well personally, but I certainly know him. Yes.
Do you know that he had done evaluations of Mr. McCollum prior to your evaluation?
I'm aware. Yes.
Let me refer you to your report when you were talking with Mr. McCollum and interviewing him for the 2017 report. He had some conversation with him about him being proud of his having a bank account.
Correct.
And he exhibited some pride about that, didn't he?
He did. Yes.
And then your evaluation of him was on August 22nd, correct?
That is correct. Of 2017. Yes.
Okay. Let me refer you to State Bar Exhibit 158. It's over on your screen. If you would read it, I'm specifically referring to an email from Mr. Thomas Harbin dated Monday, August 14, to Patrick Megaro.
Yeah, so this reads, Patrick, I don't mean to tell you your business and you may have already thought of this, but I would recommend that you have some rehearsal with Henry and make sure he knows where his bank accounts are, how much is in them, how to write a check, what his income and bills are, etc. Tom Harbin.
So you have a psychologist who's on work on the case, talking to the attorney in the case, knowing that your evaluation, you've been directed by the court to conduct an evaluation and telling him to go over with the client his bank accounts. You have a problem with that?
That's an unethical recommendation, period. I didn't know this. So that's witness coaching. That's trying to steer the results of an examination. That's no different than trying to teach someone the criteria and the DSM before a disability determination. This is bad, period. I'm sorry, this is just bad.
From the professional, from the psychiatry or the medical profession, do you find this unethical?
I find it, yeah, unethical because first of all, Dr. Harbin, this is news to me right now. So Dr. Harbin is an evaluator in the case, but has also clearly stepped outside the role of the dispassionate evaluator and is now acting as part of the team, if you will, which is something as a forensic examiner we have to avoid. If a defense attorney hires me, but I have a plaintiff's opinion, so be it. I get fired and I just move on to my next case. I got one shot at my credibility. You can't mix roles like that. This dual agency is dangerous. It suggests the existence of bias. But going above and beyond that, it demonstrates a clear effort to steer and impact the results of an evaluation in a way that is problematic. That's just my opinion, but you can probably tell it's a strong opinion. You can't, that's coaching.
When you meet, you have met Mr. McCollum twice, one in person, one on a Zoom hookup,
Right.
Due to COVID issues and other issues. When you first meet Mr. McCollum, is it difficult to get the perception that you're dealing with someone who is suffering from some mental or emotional disability?
As a layperson, would you say? If you only talk to him for a few minutes, I think that it could be easily missed. I mean, his limitations in fund of knowledge are pretty apparent, but not unusual, right? If you have to work with him in a more productive fashion, for example, okay, I'm not an attorney, but if I was working with him on something that required sort of a more abstract interchange of knowledge, complex decision-making in terms of gauging, for example, interest rates, things of that nature, then it would become immediately apparent even to a lay person that there are problems. And I don't think a lay person would be able to define those problems, but you would know that you're dealing with someone who's, now, I should say, Mr. McCollum doesn't, he will attempt to hide that, right? Because of this veil of competence, but in a contractual sort of relationship, you can't, right? Which is sort of what the DSM speaks to, that ultimately, if you try to engage in sort of more abstract, more complex, and I don't mean legally complex, but the sort of things that an attorney would normally work with a client on, you would pick up on that this is a person who has some limitations. And by that, I should say, in a post-conviction setting, everybody would have to know this, because that's why that post-conviction setting occurred, right? So everybody, even people unrelated to this case, because of the press attention and the media attention it had gotten, absolutely knew of the difficulties encountered by Mr. McCollum and Mr. Brown. You didn't need to note them. They were, you could look them up.
Let me ask you about your evaluations and specifically your most recent evaluation. In your professional opinion, is this even a close call?
On the capacity issue, it's not a close call. Now, I should say that utilizing the North Carolina language, does that mean that in everybody, by nature of having a mild intellectual developmental disorder, fails to meet the standard of capacity under North Carolina? No, clearly not. Does it mean that everybody who has a mild intellectual developmental disorder is capable? No, definitely not. But Mr. McCollum is definitely not one of the individuals that can maintain that capacity. Years and years of observation of him has demonstrated that to be the case. And Mr. McCollum is not just an individual with IDD, mild severity. He's an individual with repetitive head injuries, a diagnosed neurocognitive disorder, a mild IDD, post-traumatic stress disorder, and the resounding permanent impact of nearly 31 years in such a controlled environment that some people will acquire mental illness simply based on that housing, right? So he is one of the individuals that does not meet the test of capacity under my interpretation of the North Carolina statute. It's just my opinion, of course. Many do, right? But he does not. He has not, and he has demonstrated repeatedly, including currently, that while I think he has adult goals for his life, and I think he can attain those goals, he will need assistance in doing so.
Will there be cross-examination, Mr. Williamson?
Yes, sir. Thank you, Mr. DeVore. Dr. Corbin, my name is Lane Williamson. Can you hear me all right?
I do, yes.
Okay, I represent Mr. Megaro in this proceeding.
Yes, sir.
I'm sure you've not met me or had any interaction with me before.
I don't think so.
Okay.
Not that I remember anyway.
Well, sure we haven't. Okay. I just wanted to ask you, you made 2 evaluations of Mr. McCollum here. And I understand that they were for different purposes and commissioned by different folks, but in each, weren't you asked to determine Mr. McCollum's capacity under the statutory definition?
That part's the same, yes.
So, and as you testified at the first one, you were asked to do that by the court, by Judge Boyle. You were appointed by the court.
I think so. That was what I was told anyway.
Who told you that?
The court order. Other than the court order, I have no idea who said that. I mean, at that point, I wasn't involved in it, so I don't know. I don't remember. So,
but this more recent evaluation, you were contacted, you knew it was by the prosecution in this proceeding.
Oh, you mean the retaining party? Yes, I knew who he was. Yes,
They were the ones that paid.
correct.
And you know how it was set up with Mr. McCollum this time? Make him available. Did you do that personally?
I did not do it personally. I'm assuming that somebody from the retaining counsel's office, from the bar's office, I don't know how it was scheduled. I just know that it was scheduled. I did not personally do it.
So how did you know that the interview had been scheduled? Who communicated that to you?
So I think I provided a potential time to Mr. To the bar attorney's office, right?
Either Mr. Murphy.
Well, that's the problem. I don't remember who, but to their office. And then I think I got communications back that he would be available at his home, which is how he did it. I interviewed him from my office via communication video link to his home in South Boston, Virginia.
And so the assumption was that that had been set up by somebody from the state bar, and that Mr. McCollum would have known that he was being asked by the state bar to do this.
So it is my assumption that it was set up by these attorneys. I am not sure that he understood prior to my examination of him. I'm not sure that he understood that. I just don't know. But now when I spoke to him, he did, because we discussed it. But before that, I don't know what he was told.
And in the first examination that you did,
Yes.
you recall that there was a hearing and that Mr. Megaro cross-examined you pretty extensively. Do you recall that?
So I recall it, but I got to tell you, I don't recall it very well, to be honest. But I do recall that day. Yes.
Several years ago.
Oh, it was. Yeah.
And the reason I bring that up is because I think to the relief of you and everybody else, I don't want to go over all of that ground again, because that's inevitable.
I will not object to that. Yes.
I didn't think so. But I do want to ask you some questions about that first evaluation.
Sure.
And now you testified that you actually met with Mr. McCollum for what, a little over 2 hours?
A bit over 2 hours.
Okay.
Yeah.
And compared to your video interview this second time, that was 1 hour and 15 minutes.
That was correct.
So your total interaction in these two evaluations is face-to-face is less than 4 hours.
That's correct.
And in both evaluations, you did not do yourself any standardized testing.
That is also correct. I did not, nor could I have.
And you're not qualified to do that.
That is also correct. Yes.
But in doing, are you aware that both before and after, I think, your testimony in the earlier matter, Dr. Harbin had done standardized testing?
I am aware that I don't know what he did, but I'm aware that Dr. Harbin did examine him. Yes. But I couldn't quote to you what Dr. Harbin did.
But in any event, you have not reviewed the standardized testing that he did at any point.
If I did, I no longer remember it. I couldn't even, I don't think that I have, but it's been many years, but I don't recall reading that data.
Now, when you did, again, your first evaluation, You did some collateral interviews, did you?
I did.
And who were they with?
The ones I recall was an attorney, Ken Rose, and then Claudia Coleman, a forensic psychologist, and then Dr. Roomer, who's another psychologist.
You did not interview Mr. Megaro, who was representing you at the time.
I did not.
You didn't interview his fiancee at that time either.
Do you know, I did not, and I still have not interviewed her.
Well, most of us would think that our wives or fiancés would know something about us. Why not?
So I would agree that my wife knows far more about me than I wish would be the case, and that's probably a standard sort of observation. So here's the thing. One, I have to tell you, although I don't say this with a reasonable degree of medical certainty, I don't think Mr. McCollum's very excited about me speaking about his assessment with his fiance. I could have made a lot more noise about that. But again, once the arm is gone, the question for me is not whether, the question for me is, are my opinions held with a reasonable degree of medical certainty? In this case, I've testified repeatedly that they are. Is more information always better? Yeah. Is some information enough? Also, yeah. And for what it is worth, Mr. McCollum was not excited about me speaking with his fiance, and I suspect that I know why, but I can't say that with certainty, so I'll just keep it to myself.
Now, granted that the specific question you were asked being capacity at both times.
Correct.
And given what you testified about here is that you would not expect any change in that over time. And you knew that from your initial evaluation.
Right. In the underlying disorder. Correct.
Did you have some understanding as to why having this second evaluation was necessary for your opinion about capacity?
Yeah, I do. To be quite honest with you, I had within myself a considerable question as to whether it was necessary to re-interview him. I did. I questioned that. That's an excellent question. And it was ultimately, I decided to do so, but only after I don't know if I actually shared with counsel, this may not be necessary, but it's certainly helpful. Like I said, more information is always better. But to be quite honest with you, from a clinical standpoint, would it have been necessary if I was treating him in my office to reassess him to see if he was still intellectually disabled? No, it wouldn't have been necessary. So you make a strong point.
Well, what were you told as to why this was necessary?
I wasn't told that it was necessary. Oh, you mean why the assessment was necessary?
The second one. You testified that you questioned why this was necessary. Who did you question? Who did you discuss that with?
Oh, when we were discussing this, I shared with retaining counsel that there is no reasonable expectation that this is going to be different, and it was not appreciably different. But ultimately, nobody told me it was necessary to do it. I decided to do so, just out of an abundance of being thorough and cautious, and to some extent, I have to tell you, I feel like I know Mr. McCollum at this point a little bit, and I'm curious to see how he has adapted following the years since his release.
Well, did anybody tell you why they thought it was necessary?
No, nobody tells me what to do. They either take what I say I'm going to do, or they fire me. That's it.
Oh, well, did anybody tell you what the purpose was? Why were you being retained?
Oh, well, so that's in the report. So the reason that I was being retained is that the question had come before this jurisdiction, this court, as to whether at the times that we've been discussing about, he met or possessed the functional ability to be viewed as a competent adult under North Carolina's law. And I think that may be all I know about that. I'm not sure. That may not answer your question, but that was what was told to me, though.
But that was not a different question from what you were asked to do in your first effect.
It was largely the same question. Judge Boyle's order was not worded necessarily the same way, but the standard was the same.
It's in your report that Mr. Walthall was present?
You mean at the
The second
interview?
one.
That is correct. Yes.
Why?
I think just to make sure we got established on the connection correctly. And it's a good thing that he was there because I did it wrong, but we got it worked out. So
Now, when you're engaged by an attorney, and I take it you've done this many times.
oh yes.
Is it typical that the attorney is present during your examination?
Sometimes I ask them to be present. So for example, if questions regarding Dusky arise, that the nature of a relationship with that attorney in real time becomes sometimes, it's not usual, but it's not rare either that I would have the attorney present. So it's not unusual. Now they don't get to, in an assessment of this sort, the attorney doesn't get to participate in any way or answer questions or say things along those lines, which is how that was done here. He was simply in the room. In fact, I don't think I could observe him most of the time.
Right. In the room, what was the room? Who was in the room?
Mr. McCollum and that attorney.
Was there a Mr. Tarleton present?
Not to my knowledge. I mean, I didn't have them pan the camera around the room, but no, not to my knowledge.
But I just want to be clear that Mr. Walthall was physically in the same room as Mr. McCollum
That is correct.
during this last interview.
That is correct.
And of course, as you testified, Mr. McCollum is suggestible.
He is suggestible, yes.
And so he knew what was going on because why Mr. Walthall was there.
Well, objection sustained. You can't testify what someone else knew, but.
True. Now, but you knew Mr. Walthall was in the room.
I did.
Did that give you any concern that Mr. McCollum may react to that wanting to please Mr. Walthall?
Does it give me any concern? I have to certainly consider the possibility. I saw no evidence of that. But all things are possible. I mean, it's sort of a speculative thing. I mean, there are okay, I should take a step back. At the beginning of the evaluation, I discussed with Mr. McCollum sort of why we were talking again. Mr. Walthall didn't participate in any of that. He was simply there. Whether Mr. McCollum was trying to please him in some respect, to be quite honest, I didn't ask him that question, but I saw no evidence of it either. In fact, he expressed some displeasure at having any of this going on at all. He just wants to live his life. I don't think he cares much for any of us, to be honest with you. Sorry.
I think we can all agree with that. And how he's doing now, he owns a home now, doesn't he?
I think that is the case. I mean, it's not like I inspected the deed, but he certainly has a home that he shares with his fiance in South Boston. Yes.
And he's got a couple of cars.
I was aware, I don't know what he owns now, but I'm aware of that historically, yes.
And he's got a fiance
He's
concerned about.
Oh, yes, very much so.
And that's a fiance. She has underage kids, not his, but they're living together.
There's two, I think, that are living there. Yes.
And they're living a pretty normal life on their own, aren't they?
Seems like it. I mean, for the most part. I mean, there's things that he wants to do that he hasn't been able to do, like get his driver's license, and he really wants to get to work, and he wants to be able to get married, and he hasn't been able to do those things yet. But
About getting his driver's license, did you have any information that since he has a guardian under Virginia law, he's not entitled to get a driver's license?
not that he told me, and I'm certainly not aware of it. What he told me was that he failed it the first time because he ran a stop sign, but then that he couldn't pass the written part, and he had been taking some practice tests. Whether he's actually prohibited from getting a driver's license because of his guardian situation is not as, I don't know. He didn't know either, I don't think. If so, he kept that from me.
When you examine, and I'm jumping around just a little bit.
It's okay.
When you examined him the first time, did you know that he had actually testified before Judge Boyle before you?
When I don't remember, I am aware as we sit here today that occurred. I honestly don't recall whether I knew that in real time. It's just been too long, and too many records. But I'm aware of that having occurred.
In any event, with your first examination, I know you examined a lot of, well, it's forensic, so you examined a lot of material.
Right.
Did you examine how he held up under questioning at that sworn testimony just days before your examination?
So if in the sources of information, if that hearing was a hearing of May 5, 2017, then the answer would be yes, at least in written form. If it's a different hearing and it's not otherwise listed in the collateral sources, then the answer would be no, I didn't.
Now, in between that first examination and the second examination, are you aware that in the civil suit that is still pending, he testified under oath at a deposition and was questioned by several attorneys?
I certainly have not read the deposition, and I don't think I'm aware of it either. Was aware of it.
In any event, nobody brought that to your attention before doing this second evaluation.
Right. Again, if it's not, that is correct. So while there have been sort of some additional records that I've become aware of, like the email and everything, unless I've just forgotten it, I don't recall reading a deposition in a civil case.
If you had known that he had testified at a deposition, would that have been something that you would like to have reviewed as part of your updated evaluation?
Would I like to review it? I'll put it this way. All information is useful information. Yes. To the extent, if the question was, would I have liked to review it because I think it might change my diagnostic and forensic opinions? While all things are possible, I think that's inherently very unlikely, but it's not impossible. I want to be fair about this. It's not impossible that it could yield information that is not only useful, but influences my opinion. It's exceptionally unlikely, though.
But in any event, you didn't have the opportunity to review it because you were not made aware of
it. That, unless I have just totally forgotten about it, I do not recall reading a deposition in a civil case. Just some hearing transcripts.
One moment. Just to be clear, you know that Dr. Harbin and Dr. Ballard issued their own reports after your initial one.
That, yes, I'm aware of that.
Have you reviewed those?
I've reviewed Dr. Ballard's report, and Dr. Harbin has actually written more than one, and I think I've read them all.
And would you agree that each of them is competent in their field to issue such a report?
Yeah, I think that Dr. Harbin and Dr. Ballard have the credentials, training, experience, and to work competently in the field. Now, give me one moment. I am deeply concerned about what I've become aware with Dr. Harbin's sort of dual agency in this, but above and beyond that, Dr. Harbin is a respected individual in his field. I've known of his work and have worked on cases that he's been on over the years on more than a few occasions. The same with Dr. Ballard, who I consider a friend. I think they're both very wrong about this, but that's just my opinion.
Well, that's your opinion.
That's great. That's right. Yes.
That opinions here differ.
Absolutely.
And
Absolutely. Which is why I'm glad I sit here and not there. Right.
That's not surprising. Opinions differ.
It happens with some regularity. These differences of opinions, though, I think are a little make me scratch my head a little bit. I mean, the fact of the matter is I do respect both of these individuals, but in this case, I'm a little like flummoxed about that, especially given the prior evaluations. But nonetheless, it is what it is.
Okay. I'm almost done. Your evaluation in each case is about capacity. And even though you might have been asked, well, capacity in connection with specific transactions, loan agreements with Mr. Megaro,
Correct.
your conclusion is, how to put this, it's not specific to those transactions. In other words, your opinion would be the same for other transactions of that nature.
So I'll give you a yes, no, and then I'll explain that. Yes, my work, even though I am aware that is to answer certain specific questions, my work really centers around defining those deficits and comparing them to that statute. Do his deficits cause him to fall under the bright line of that statute, to the extent there is a bright line of that statute? My opinion is that it does. And so that if Mr. McCollum were to enter into some contractual relationship elsewhere or make some weighty healthcare decisions, that it's not just me, the DSM says that somebody like him is likely to require assistance. And as such, I go back to my original answer. Yes, I think that the concerns could be raised in similar situations, calling for a similar range of adult sort of decision making and comprehension that are difficult for him at best.
And I take it based on that answer, you would agree that you would have the same concern when faced with an engagement by Mr. McCollum to pursue the same kind of litigation, 1983 litigation, that Mr. Megaro did. You would have that same consideration if he contracted with some other lawyers.
So we're not talking about Dusky sort of capacity. We're talking about this capacity. And in the abstract sense, yes, I would, because knowing of his history, for him to engage in a complex contractual relationship, extra steps should be taken, more should be done. So I'm not a lawyer, I'm just a psychiatrist. But yeah, the concerns, the worry for me would be there that, you know, what is this decision about? Is he making this decision because they're nice and gave me money? Or is he making this decision with assistance, and that assistance and those safeguards being to ensure that he did possess that knowledge and did engage in sort of an adult reasoning process. So yeah, in the abstract sense, if he were to do that today, I would be concerned about it. If he was told to leave his home in Boston and go hire an attorney to go start a corporation or something, and we're going to draw up corporate, I would be very concerned about that without knowing more.
And you'd also be concerned if he did that before hiring Mr. Megaro. In other words, after he was released from prison and before Megaro, if such a
That would be potentially the case. Now, let me expand on that slightly. So that, yes, that could potentially be a problem. I wasn't asked to assess his understanding of those events. And it's not that without assistance, someone can't make decisions, right? So he has a guardian to enable him to get through some of these decisions in life and get through management of his funds and things of that nature. But without any assistance and without any safeguards being in place, I would have some, knowing nothing more, could be concerns. Yes.
thank you. That's what I'm saying.
Any further?
You're welcome.
Any further direct?
Yes. So, and that's just exactly what Judge Boyle did. Regarding that line, Mr. McCollum.
That's my understanding of what occurred.
Mr. McCollum had the assistance that the guardian ad litem going out and hiring new attorneys. Guardian ad litem would essentially act in his stead, advised him, determine whether the financial arrangement with the lawyer is something that's fair.
Right.
For instance, whether you would $500,000 fee out of a case that's a guardian would be there to assist him.
That is correct. So that's my understanding of what procedurally occurred and why the judge took that step and why a counsel at the time actually was himself concerned about making sure that, because, we don't have a situation where attorneys can substitute their judgment per se, just out of fact, because a defendant might be slow or retarded. It doesn't work that way. And so I'm not a lawyer, but having done this for a long time, I think that Judge Boyle handled it in a stellar fashion, what he did in terms of the guardian appointment.
Now, you asked a question by Mr. Williamson about whether collateral sources and whether you talked with Mr. Megaro.
Right.
Regarding the first, did you try to reach out to Mr. Megaro?
I did call his office, yes, and left a message with him.
Did he return your call?
No. There was some question about there was a hurricane around the time and some confusion about that, but I had called and was able to leave a message, but didn't hear back.
Did you feel compelled to continue to check again if he was not going to return your call?
Well, I wouldn't usually.
Pardon?
I would not usually. Yeah.
And so you attempted to contact him and you left a message to return the call and he did not get back.
That's my recollection, yes. It's been a long time ago, but yes.
Now, the evaluation you did for the state bar was an evaluation as to whether Mr. McCollum, that's part of your report. Page 505 of 669.
Yes, sir.
That last paragraph, when it starts out, is as such.
As such, it is the opinion of the undersigned with a reasonable degree of medical certainty that Mr. McCollum met the statutory definition of incompetent adult as detailed in North Carolina General Statute, Section 35A 1017, during the period of time relevant to the current evaluation.
So not only did you lack the capacity during those times, actually he was not.
Correct. So I guess the terms you're correct. They're not synonymous. They're related, but both of those, I agree with both of the statements you just made.
Now, you asked about whether Mr. McCollum owned this house, or are you aware that the house is in a river?
I was not aware of that.
By someone else?
Was not aware of that. Although the more I think about it, I assume that would likely be the case, but I was not aware of it.
Very much not.
Any recross?
Just short. I may not have made it clear in my questioning about another agreement with attorneys to pursue this claim. I did not mean to say that it was one with a guardian.
Oh, sure, I understand.
Yeah, but you would have that concern if it were done without a guardian.
Right. And I'll just use the term safeguards. Without safeguards, assistance, confirmation of reasoning behind things, yeah, those concerns would exist and they will exist in the future as well.
All right. So a guardian would be sufficient, but what other safeguards could there be?
So one of the safeguards can be an assessment of, I've actually done this before, an assessment of an individual's reasoning and logic behind making a certain decision. So this comes up a lot in situations where psychiatric patients or intellectually impaired patients are refusing life-saving medical care. They can do that a lot of times. A lot of times they can't. And so consult liaison psychiatrists are often called in to make a determination for people that don't have advanced healthcare directives or POAs over healthcare, to look at the reasoning behind the bad decision, if you will. And even someone who has a severe mental illness can make an unwise decision if the unwise decision is not the product of in a critical way of their illness. And so I've rambled on so long, I forgot your question, but one of the safeguards can be further clinical assessment of their status at that time.
And I think you may have already said this. I just wanted to make it clear. Not everybody who has intellectual developmental disorder of mild severity needs a guardian.
That is correct. Right. Some people, I mean, a guardian is a legal construct. Some individuals who have mild IDD have sufficient support, assistance, supervision without the involvement of court officials, and it works just fine for them. Others don't. So not everyone, in my experience, that has mild IDD is appointed a guardian.
All right, thanks.
Dr. Mr. Morris, questions? No. Mr. Bennett? Dr. Corbin, under 35A 1101, there are other definitions other than just incompetent, correct?
That is correct.
There's intellectual disability and mental illness. Can you talk a little bit about your evaluation? Was it limited to, I think it's subsection A, the incompetency issue? And if so, did you also make determinations as to, for example, intellectual disability or mental illness?
So the answer is both, and here's why. If a person engages in conduct or decisions that all of us would think are horrible decisions, and they similarly have, I'll say, schizophrenia, a mental illness. If the bad decision is not due to that mental illness, they're not incompetent, right? My understanding as a forensic practitioner is that unless there's a connection between those two, the capacity issue and the illness and intellectual issue, that is really not an issue for the court, right? In terms of capacity, people have the right to make stupid decisions, whether they're ill or not. But in this case, what you have to do is look functionally at that capacity issue, that what is involved in doing the things the statute talks about. And then separately, do they have a DSM condition? If the answer to both of those is yes, they have a condition, be it ID or PTSD, or in this case, both, right? And they have a demonstrated lack of, I'll just call it adaptive functioning skills, right? They don't do well without support. Then the ultimate question is this problem, i.e. their functioning problem, due to the illness diagnosis problem? If that then becomes the case, then it would be, as a forensic examiner, I'd say, yes, they fall under that standard, because there's really kind of two prongs of it. I don't know if this is answering your question. The other part I thought you were asking is that intellectual disability under the law, for some reason, is sometimes subsumed separately than mental illness, even though as psychiatrists, we don't think that way. And so in terms of mental illness, it would be as post-traumatic stress disorder. In terms of mental illness, it would be as neurocognitive disorder. But for some reason, intellectual disability has always been sort of thought of separately from mental illness. Under the old multi-axial diagnosis system that we used to use, intellectual disability wasn't even an Axis 1 diagnosis. So Axis 1 would be what the statute talks about mental illness, and Axis 2 included things like mental retardation. But it's an artificial distinction that we've gotten rid of. But still in law, in a lot of statutes I see around the country, it's sort of.
Sorry, I couldn't hear.
Sorry, it's sort of set separately. I don't know what I did to make that happen. I don't know if that answers your question at all.
As a result of my questions, does either of the parties have any additional questions?
No, Mr. Ford.
All right, thank you. We'll take our noon break at this time. Why don't we come back about 1:15? Dr. Corbin, I'd ask if you would to wipe down your cubby there.
Yes, sir.
And we'll see everyone have a nice lunch. See you at 1:15. Yes, this is me as far as I'm concerned, we release them.
Thank you, sir.
Don't deserve it. Thank you.
Have you, what are we doing after lunch? Let me know.
Yeah, I thought you said.
Oh, yeah, okay. Yeah, fine.
Yeah, let's see.
Thank you so much, Donnie. You're just one of my best friends.
Mr. Tarleton, I believe there's a notary there with you. So we can either have that person verify your identity, if I understand the rules correctly, or I think the clerk can do it from here. Is that correct, Mr. Chair?
Under the remote rules, I think that's probably the existing rules. I think she can do it remotely, should she choose to do so.
Okay, Amy, how would you like to do that? Do you want to? Okay, Mr. Tarleton, would you hold your license up to the screen so that
Sure.
the clerk can verify that it is you? That's blurry for some reason. Oh. There it is. Yeah, hold it right there. His driver's license number. Would you indicate your driver's license number, please, Mr. Tarleton?
250, 154, 25.
And the expiration date?
November 4th, 2026.
Is that all you need, Amy? Okay, thanks very much. Mr. Tarleton, would you please introduce yourself to the panel? I know you cannot see them, but they can see you. So if you would just introduce yourself to them, please.
Absolutely. My name is Raymond Tarleton.
And how are you currently employed, Mr. Tarleton?
I'm in a private law practice, the small practice I have with my law partner out of Raleigh.
Oh, yep. Hold on. The clerk does have one more thing for you, Mr. Tarleton.
Hi there. We need to get you sworn in. If you
Okay.
raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do. I swear to that.
Thank you.
Thank you, Amy. So, Mr. Tarleton, I believe you're saying that you are an attorney with a private law firm in Raleigh?
Yes.
And how long have you been a lawyer?
Since the fall of 2008.
And have you always been in private practice?
No, I started out as a prosecutor doing like misdemeanor offenses in the Wake County District Attorney's Office from the fall of 2008, I think up until right at maybe 2010. I office shared with a lawyer out of Raleigh, Dan Boyce, who was doing a lot of federal work, and I was doing contract work with him, and I got on court appointed lists. So I had my own small law practice, but like I say, working with that lawyer for at least a year and a half. And then by, I think it was late the September or so of 2011, I was given a job offer at the Federal Public Defender's Office as an assistant federal public defender in for the Eastern District of North Carolina, but based out of Raleigh. And I did that until maybe October or so of 2013, when I just decided to start my own law practice again. I was in a solo practice from that time until June 1st of 2016, where I merged my solo practice with my law partner's then solo practice. We started our partnership, and that's what I'm still doing now. It's called Tarleton Polk.
And what generally type of work do you do? What types of cases do you try?
Primarily criminal defense cases and appeals. A lot of my focus is on federal criminal defense, but also state homicide, murder cases, including capital cases. In appeals in the Fourth Circuit Court of Appeals, I've done some appeals in the past through the court appointed system with mainly with the North Carolina Court of Appeals, and we've done some kind of smaller levels in civil litigation.
Could you tell the panel a bit about how you became involved in this matter?
Yes, just for a little background, so I really in earnest started doing federal litigation or federal criminal litigation and federal civil litigation in the context of civil commitment of people accused of being sexually dangerous people who are nearing their prison sentences. And so there's civil commitment trials essentially that happen. So I was doing that with the Federal Public Defender's Office and so I practiced in front of every federal judge in our district, magistrate and Article III district judges. And I did a lot of work in front of Judge Boyle, including trying cases with him and in front of him. And when I left the Federal Public Defender's Office, I would get sometimes appointments directly from that court in federal post-conviction matters that can have a lot of interesting constitutional issues, just like the federal civil commitment issue cases. I think I tried the very first one in the Eastern District of North Carolina in front of Judge Boyle. I had a lot of really enriched constitutional issues. So over time, I've been getting occasionally appointments to handle post-conviction in front of him. And then I think it was in May of 2017, lawyers, I believe it was originally for civil defense lawyers, maybe for the town of Red Springs and Megaro. Those people, they emailed me saying that I was guardian ad litem for Henry McCollum. And I guess through some fluke, the case manager for the federal court had not actually sent it to me by email or something. And so I wasn't attached to the case in CMACF. That's how I first heard about it from the lawyers. And then I got on the docket and I saw the appointment order. And then so I realized he had appointed me to be, guardian ad litem in this case.
He being Judge Boyle?
Yes.
Okay. And could you help the panel understand just a bit more, or at least help me understand a bit more about what it means to be a guardian ad litem for someone?
It's so either someone who's a minor under the age of 18 or someone who is incompetent under civil standards, which is different than criminal standards, criminal trial standards for competency. But if they're incompetent for purposes of civil litigation, if they're an adult, they can't prosecute the case in their own name. And so that effectively, by analogy, they're considered like a child, and you have to have a competent adult to exercise the client powers. And so I think it's under Rule 17 of the Federal Rules of Civil Procedure, the court had made a determination at what appeared to be a prior hearing in the appointment order for me that Henry McCollum was in need of a guardian ad litem, that he was considered an adult incompetent, and his interests had to be protected.
Do you know if the court's decision to appoint a guardian for Henry was contested?
You know, ultimately, we got the transcript of the hearing, and the hearing has also been reported in the news, where there was an attempt to settle with Red Springs, one of the civil defendants in this case, prior to my appointment. Maybe it was about a month prior. I don't recall the actual date. And my read on the transcript of what was reported in the news, ultimately I did see the transcript, was the judge started calling into question whether Megaro had a legitimate or valid fee agreement with Henry McCollum, since the court had, I think by that point, an enormous amount of the case history in front of it, whether it had a valid agreement, and if not, trying to settle it up, presented in the court's mind a conflict of interest. In my understanding, my read on it was Megaro actually seemed to concede that the court could, on its own, appoint a guardian. Not that Megaro hadn't petitioned for that, but I think there's discussions about the federal civil rules and I guess what's effectively codified in Rule 17, and then the court, in the order, cited case law, discussing its power to appoint a guardian, even if someone has not actually been formally adjudicated incompetent under state law. And that, yeah, so the transcript too, the town actually that was trying to settle the case, the lawyer Dan Hartside, I think at that prior hearing before my appointment, had said that they had initiated a request that some kind of investigation whether he would have capacity to agree to a settlement, that they had concerns based on the presentation given to them, whether it could be confident, this could be a legitimate settlement. So that was, coming from Henry McCollum's, opponents in this civil litigation.
What steps did you take upon being appointed a guardian in the case, and what documents did you review?
So I talked with Patrick Megaro. I believe he wanted to have a meeting where he would be present with his co-counsel Scott Brett Schneider and Henry McCollum. Initially, talking to my law partner, thought I should meet with Henry alone initially, or with my partner would go with me, but we would go up and meet with Henry and try to get his take on the settlement and any other issues that were going on. And Megaro sent me through Dropbox links, a lot of case file materials, both from the decades of litigation in the criminal case as well as the civil case. That those were some of the initial documents that I obtained. Also, so my partner and I went up and drove up into Virginia and met with Henry McCollum too, to talk about this proposed Red Springs settlement and other issues.
After speaking with Henry that first time, did you form a belief as to whether or not he did in fact need your services as a guardian?
Yeah, it became, I'd say, at least 10, 15 minutes into the conversation. What struck me was, somebody that appeared to be impulsive, who was out of money, living in a small house, who apparently had bought cars but never had a driver's license or couldn't pass the driver's license test, effectively couldn't live without the assistance of a fiance and an uncle at the time that were helping him out. They were living in rural Virginia, just getting around, living in rural Virginia. Like I say, not, complaining about being broke, essentially. I think living off of Social Security disability at that time. And it sort of presented as sort of an older child, frankly, but a good-hearted person who had been incredibly wronged, but very impulsive and naive and suggestible.
And let's take a look at, we'll share our screen here, Mr. Tarleton, and show you Exhibit 156. Can you see that document, Mr. Tarleton?
I don't believe I can. I think it is. Now, yeah, it's popping up now. I see it now.
I am not to thank for you being able to see that, but my paralegal is, so I'm glad you're able to see that. What is Exhibit 156? We can just stay on the caption right now.
That appears to be that's a request that I filed with the court in anticipation of a renewed hearing that was going to happen on the proposed Red Spring settlement, where I was asking the court sort of a fundamental issue to formally determine whether or not there was in fact a valid fee agreement in this case that would between Megaro, his firm, and effectively Mr. McCollum. And in some meetings with Megaro, I'd gotten the impression that he thought that his agreement was still valid, even though the court had said things otherwise. That is just a fundamental issue. Anything that could be done in the case kind of centered around that. Like, what if new counsel had to come in? What's the status of Megaro's abilities to claim legal fees and things of that nature?
So was this Exhibit 156 one of the first actions you took, I guess, from a formal pleading perspective as guardian for Henry?
It was. This case involved an enormous amount of information, and but we had the court was going to be scheduling a based on the docket that they were going to obviously reconvene a settlement hearing at some point, and maybe one had been scheduled, but that was what I was anticipating, and I'd seen enough by now to know that there were absolute concerns with not just whether there was a valid fee agreement, but whether a conflict of interest existed between Henry McCollum's interests and Megaro and his firm.
Well, let's go through the 5 concerns that you mentioned in this pleading that you filed. If you can see that first part there, you're welcome to either read it into the record, or if you would prefer, just to summarize what your first concern is here that you list in this pleading.
I've got the camera right in front of the screen too. All right. So first concern was whether the representation and contingency fee agreement is invalid, or whether over Henry McCollum lacking sufficient capacity to enter into such an agreement without the assistance of a guardian or independent counsel.
What led you to that concern?
That based on a history, based on the court already appointing me, the fact that I'm a guardian ad litem to me presupposed incompetence. The court had an enormous record in front of it, including citing to I think one of the U.S. Supreme Court justices in a cert petition that had gone up from Henry McCollum's criminal case, where one of the justices thought he was too intellectually disabled to be executed, and based on IQs that had full-scale IQs that is tested as low as 59. My understanding of intellectual disability as being a static thing, that is something that it can never be cured over time. That if he was intellectually disabled, then even if he could meet the low bar for competency under a criminal case, he just couldn't meet the higher bar for competency in a civil case, and that is including the capacity to enter into binding contracts or agreements. And I mean, hence the whole point of why a guardian has to be involved for an incompetent adult in a civil litigation.
And Mr. Tarleton, the portion you're referencing from the United States Supreme Court, That was in the dissent, is that correct?
That was a dissent. That's right. There, yeah.
Let's look at your second concern. If you could scroll down just a bit there. What's the second concern that you reference in Exhibit 156?
The second concern was that the fee agreement contained language that said that there was this irrevocable, contingency fee, that even if Henry McCollum fired his lawyer, Megaro and the firm and the associated counsel, that they didn't have to, at any point in time, wouldn't have to, get involved in it, that they could still collect a full one. I think it was a staggered contingency fee, but anyways, collect their full fee, even if they were terminated at any point in the litigation, which the logical implication, if you understand these things, would be what new lawyer would take on the case if you wanted to change counsel, if that were actually true. But my initial read on the rules of conduct in North Carolina was that you can't do that. So there was concern that was an unethical provision in there.
And before we move on to the third concern, if we could just go ahead and look at Exhibit 105, that retainer agreement, so that we can read that language specifically. Have you seen Exhibit 105 before, Mr. Tarleton?
I have.
I'm going to have you read a portion of it. 1 second. Let's look at page 3 of Exhibit 105.
Yeah.
And if you'll start reading there, it's going to spill over onto the next page, but I'm confident we can follow along. If you'll start reading there at when you sign this agreement.
When you sign this agreement, you are conveying to us an irrevocable interest as outlined herein in the net proceeds arising from the prosecution of the matter, whether obtained by settlement or by judgment or otherwise, and whether denominated actual damages, costs, attorney's fees, punitive damages, or other recovery, and in whatever form they may take in the event that's held.
Mr. Talbot, thank you. Just that sentence. And then if we could go to page 4, beginning at if you elect. Yeah, there at the bottom. If you would read that, Mr. Tarleton.
If you elect to terminate this agreement, it will not terminate our contingency interest in the outcome of the matter. Should you breach this agreement in such a manner that we are reasonably required to withdraw or terminate the agreement, we will attempt to accommodate new counsel should you choose to hire new counsel. But while we may choose to do so, under no circumstances are we required to relinquish any part of the contingency fee provided herein in order to make that accommodation.
Thank you, Mr. Tarleton. Is that the language that you were concerned about that's referenced in Exhibit 156?
Yes.
Based on your experience as Henry's guardian, do you believe Henry understood this agreement that is Exhibit 105?
No.
Why not?
Because
Early objection, you can't understand what's in somebody else's mind.
Would you repeat the question, please?
Based on your experience as Henry's guardian, do you believe Henry understood this agreement? Why not? He is the guardian. It's based on his personal experience. I believe under Rule 701, he's allowed to testify to it.
Overruled.
Go ahead, please, Mr. Tarleton.
no, I mean, I saw hypocrisy between any claim that he could understand this and simultaneous claims going on in the civil litigation that he couldn't understand what the purported confession that Red Springs was trying to have him, or excuse me, Red Springs, Robeson County Sheriff's Department and SBI agents were trying to get him to sign off on in the year 1983.
If we could go back to Exhibit 156, what was your third concern, Mr. Tarleton?
Concern emerged based on, in a relatively short time frame. We learned that there were loans outstanding with Henry McCollum, and that had a purported connection to the civil case, and also, women that were, I guess, styled as social activists for hire, that were out in the news claiming that they had an agreement and they had rights to, percentage of the civil case, to rights to the industrial commission money that had been paid out, rights to loan proceeds, things like that. So what caught my eye in the proposed, what had been filed on the docket before I was appointed by Megaro and his firm, that the plaintiff shall satisfy any and all liens that have or may yet become attached. And so, remember when Megaro and Brett Schneider came to my office to see me, that was one of the points I tried to raise, like what loans or liens are out there. And I did not, without a direct response, my recollection is it was something like that. Yeah, there may be a loan out there. Well, we learned on further, pressing the issue further, that there were actually 2 specific loans with multi-funding, this company that does some kind of litigation finance that were very complicated once to understand exactly the interest and everything else in their terms. Once I got my hands on those documents, and also, I learned later on, after Megaro was removed from the case or fired, that this individual named Derek Hamilton had given loans with Megaro's assistance in creating those documents, and that. So, anyways, that became my real concern. If Henry's doesn't have capacity to contract, how could these loans be invalid? And what loans have been paid off, where there's legitimately paid off, and what loans or other obligations are going to be claimed coming down the road? And I felt like that was a logical issue that would flow from whether the fee agreement with the Megaro's firm was invalid.
Thank you. And we'll look at some of those loan documents separately. They're obviously, as you mentioned, they're a little complex. So let's move on to your 4th concern here. What is your 4th concern reference here, and what led you to it?
Well, one thing I realized initially, it was out in the news that Henry and his brother Leon were awarded, I think back in September of 2015, about a month after the federal lawsuit was filed, they were finally awarded what is effectively an industrial commission formulaic payout that's mandated by statute in the event that you get a governor's pardon of innocence. And there's another legal basis that you can get an industrial commission payout under a formula, but the only basis that was applicable in Henry and I guess Leon's case was a governor's pardon of innocence. And so it had been reported, widely reported, that the industrial commission had awarded each brother $750,000. So that was September of 2015. What I also realized was Henry had an outstanding loan. Of course, I had real serious questions about the legitimacy of that loan, but an outstanding loan with multi-funding that had been taken out, I think, for $50,000, and then another round soon after for $15,000 that were still not paid off or satisfied. I think that's 8 months after being awarded $750,000 from the Industrial Commission.
And why did it concern you that, just a few months after receiving that award, he was taking out loans at, for $50,000 and $15,000 at 18% interest compounded every 6 months?
I mean, somebody that has gone through $750,000 of tax-free money in roughly 8 months, or at least the everything you're seeing, all the factors are suggesting that's what's happened. It raises an absolute concern about a fundamental question about mental capacity, the ability to manage your affairs, but also too did anyone manipulate or take advantage of them? You know, and because that was a big theme in how they wound up convicted. In the criminal case, the purported alleged confessions were the case, and the whole civil litigation was built around this, you know, a narrative and frankly the truth that they were easily manipulated and suggestible given intellectual disability, or back in the 80s, it was called in the court system mental retardation. And you know what happened to that money? In the very first visit with Henry, who seemed to be solely concerned about getting another, you know, cash infusion from Red Springs, that proposed settlement, and frankly frustrated they saw me standing in the way of that. What I noticed was he immediately shut down when I tried to bring up the topic of what happened to his industrial commission money. And that was also a recollection I had from my first meeting in person with Megaro and Brett Schneider. When I tried to get into that, it was told, it was either the first meeting or phone calls, but the bottom line is told that that was outside, that industrial commission is a separate matter outside of the my powers as just having oversight over the federal civil lawsuit. And so I was getting shut down. But when I got the loan documents, I saw this man has blown through an enormous amount of money. I don't know what has happened to it. And it really calls into question, has he been manipulated, taken advantage of, or swindled?
When you eventually received the documents and were able to review everything, did you learn that he had in fact not received $750,000, but actually had received roughly $360,000 out of that industrial commission award?
It took a while for that to come out. There was a hearing, I think, in August of 2017. The court ultimately appointed an evaluator. Because after I filed this request, Megaro and his firm made numerous filings of, you know, effectively trying to get me removed from the case, declaring that Henry didn't need a guardian. He's fine. They made claims that he's never been. There's no evidence that he's mentally retarded. Or intellectually disabled is what it's called now. Things like that. And so there were efforts to try to remove me from the case. And I think at one of the hearings where there were attempts to do that, Judge Bull brought up what happened to the industrial commission money, and Megaro was objecting to it as outside of the scope of the federal case.
But did you eventually find out about that, that he didn't in fact receive 750, he received 360?
Eventually, it took the Red Springs settlement. I don't recall. I know for a fact we knew exactly, or had a strong idea of an accounting of the industrial commission money once a general guardian, or what in Virginia they call a conservator, was appointed after the court, despite my concerns with the Red Springs settlements and its valuation. The court ultimately, months later, approved it at Megaro's, you know,
we'll get into that, Mr. Tobin.
Right. And so we got a guardian appointed in Virginia to create a special needs trust, and they had the authority to demand a full accounting. And ultimately, we were given finally representations on what had happened to the you know, the monies that had flowed in over the years.
And once you learned that, and thank you for detailing how you got that information, but
Yeah.
once you learned that Mr. McCullum, instead of blowing through $750,000 in 6 or 7 months, had only blown through $360,000, did that assuage your concerns, or did you still have concerns about his ability to manage his financial affairs?
Well, based on the obfuscation I was experiencing, I strongly suspected that a significant legal fee had been taken from the industrial commission payout. And so ultimately my concern also was if when I got the file, I'll back up for a second. You know, he was released from prison, or his convictions were thrown out in September 2nd of 2014. At the time, he had a pro bono team representing him, consisted of Center for Death Penalty Litigation lawyers, I believe the international law firm Wilmer Hale, and I think before that there had been a Duke law professor on that case too. But anyways, at least CDPL and this giant law firm Wilmer Hale. And as part of a pro bono continuation of assisting Henry and Leon, there was petitions in 2014, petitions for a pardon of innocence to the governor, which would, because if those are given, he's automatically entitled to each brother entitled to $750,000 as a matter of statute. And $50,000 a year, capped at $750. And the 31 years of wrongful incarceration on death row, that would be the payout. So the elected district attorney of Robson County, Johnson Britt, anyway, well, Mr. Britt at the time, there's different Brits down there, but it had written a letter to the governor just outlining his belief that Henry and Leon's civil rights were violated and all this. And the governor's office apparently got the SBI to start a new investigation. So all that is by way of background to say this. My concern was Megaro and his firm, by the time they got involved in the case in 2015, the pardons had all been teed up, the petitions had been filed. I know that Megaro and Brett Schneider claimed that they had had a meeting with the governors and that they were taking credit for the pardons coming in. But from what I was seeing, based on the objective, timeline of everything, that they were not the procuring cause of the pardon. So then it begged the question of if they took what's otherwise considered to be a legal fee in traditional civil litigation, a third contingency fee from each brother's industrial commission payout, to me that was a clearly excessive fee for effectively ministerial or pro forma representation in an administrative hearing that was uncontested. So that was a real concern. What's happened to that money, and then what other monies were charged, and where did that go?
And after the court entered an order invalidating the agreement between Henry and Mr. Megaro, did the defendant being Mr. Megaro, ever refund the money he had collected pursuant to that agreement to you as the guardian or to Henry?
No. After the first order came out, I believe Megaro's next move was to demand, had another evaluator without or any kind of input from me or involvement by me, had another evaluator evaluate Henry, ask for a new hearing on it, trying to make out the case. He made renewed efforts throughout the fall of that was 2017, the fall, to remove me as guardian and get a ruling where eliminate any need for a guardian.
And so
that was a continued effort. So ultimately, after a hearing in December of 2017, the judge denied Megaro's attempts to remove me as guardian. And despite my written, concerns with the proposed settlement at Megaro's advocacy in the courtroom, approved the Red Spring settlement. So afterwards, we had to start dealing with where this money is going to go and all that, and what legal fees Megaro was going to try to collect. And my demands were, you need to start paying back this industrial commission money before we can even have a conversation about any new fee agreement. But the reality was, it was a hard process. I believe strongly that Megaro and his associates on the case, the other lawyers, were conflicted, would lack absolute credibility with any jury in the case, with things that can emerge on here.
Mr. Charles,
and so
that's fine. Thank you. I don't know if you heard, but there was an objection. It was sustained to your last statement. So let's move on. Just to be clear, to date, as we, you sit there and we stand here today, has any of that industrial commission money been returned to Henry?
No.
Okay. And is there another contract that has not been invalidated that would give the defendant the right to that money?
Not that I'm aware of.
Okay. Finally, what was your last concern there on Exhibit 156?
The concern was let me see this. If you can just, yeah. Or zoom it back a little bit, please. The concern was if money was taken without authority, that Henry had a claim to go after it. And so if you have a claim against your current lawyer, that presents a conflict, and the lawyer could theoretically take steps to protect their ability to try to maintain monies collected in, you know, in a reverse relationship to the client's rights to try to unwind that.
Okay. I'm going to show you a few more exhibits, Mr. Tarleton. During your review of the documents and underlying materials when you became Henry's guardian, did you come across communications between Mr. Megaro and Deborah Pointer and Kim Weeks?
Yes. There, you know, Pointer Weeks wanted to get money, and I believe they sent their whole packet of information that that they claimed that they had a legitimate agreement with Henry and Leon and the Henry and Leon's sister Geraldine.
Okay, let's look at
As
the
sort of a,
agreement.
yeah, and the Megaro as well in his firm, that they had this kind of global agreement on to pay them for their role in the case.
It's exhibit 109. Let's take a look at that. Before today, had you seen exhibit 109?
Yeah, I've seen this before.
And is this the contract that Pointer and Weeks had Henry execute with them?
Yeah,
Had executed.
this appears to be the contract that they were claiming that they had, and that they claimed that Megaro had approved of.
Okay, and if you would, please read the part that the paragraph that says a rate right there. If you would just read that whole paragraph ending at settlement, please.
Okay. In consideration of the services to be performed by a consultant under this agreement, nonprofit will pay consultant at the rate of specified for time spent on consulting services. Consultant shall submit written signed reports of the time spent performing consultant services, itemizing the reasonable detail of the dates on which services were performed, the number of hours spent, and a brief description of the services rendered. Geraldine shall pay consultants the amounts due pursuant to agreements, and then parentheticals, 10% of monetary advance, 5% of penal funds, 1% of civil lawsuit settlement.
Okay, and Brittany, if you'll scroll down and we'll look at page 5 and 6 of the same exhibit. Had you seen these emails between Mr. Megaro and Deborah Pointer and Kim Weeks in your services as Henry's guardian?
Yes.
Okay. Is it your understanding from your review of these and as Henry's guardian that Deborah Pointer and Kim Weeks sent their that contract that we just read a portion of to Mr. Megaro?
That's my understanding, that he had acknowledged receiving it and they sent it to him.
Okay. And when you say he acknowledged receiving it, is it got it, thanks, that we're seeing there?
That's right.
Okay. In this email exchange, and Brittany, you're welcome to kind of scroll down. Do they also discuss the loan issue? You see there at the top, we have handled the loan issue.
Yes.
Okay. As guardian of Henry, can you think of any benefit to Henry that would be gained by that information about the loans being shared with Deborah Pointer and Kim Weeks?
It just, you know, it seems like the kind of work product privilege bubble is getting undermined. Like, you know, that.
Well, overruled, go ahead.
Go ahead, Mr. Tarleton. What concerned you about that information being shared with Deborah Pointer and Kim Weeks?
That these are non-lawyers receiving kind of inside material information about effectively, you know, they're learning kind of inside strategy almost.
Okay, let's look at exhibit 613 and we'll take a look at page 11, I believe it is. Oh, that can't be right. Scroll down a little bit, Brittany, if you would. It's my fault. Keep going. Yes. Do you see there? It's hazy, which is the condition in which we received it in discovery. But can you read that, Mr. Tarleton, the email from Patrick Megaro to Kim Weeks and Deborah Pointer on February 27th, 2015?
Retainer is attached again. Please confirm receipt. Sometimes these got rejected by servers.
So is it your understanding as Henry's guardian that Mr. Megaro sent his retainer agreement to Deborah Pointer and Kim Weeks as well?
Yes.
Can you think of any benefit as Henry's guardian to a non-attorney, someone who's not the defendant, Mr. Megaro's paralegal, receiving a copy of the retainer agreement?
Not really.
Okay. Let's look at exhibit 108. You'll scroll down just so you can see the whole thing, including the initials there. Okay, Mr. Tarleton, have you previously seen exhibit 108?
Yes.
What is your understanding of what this document is?
That part of the loan distributions on the initial multi-funding loan.
And the defendant has admitted at his deposition that those initials there at the bottom are his. And do you see how the money is being dispersed there at the very top of the page that you're seeing right now?
Yeah, my understanding was there's initials for payment to the landlord for the house where Henry and Leon were living at the time. $5,000 out of the money to Miss Pointer, another $5,000 to Miss Weeks. I guess apparently purported to their alleged contract.
And that's fine. I just want to ask you about two of the ones you've already mentioned. As guardian of Henry, can you think of any benefit to Henry that would be gained by money being paid to Deborah Pointer and Kim Weeks against Henry's future recovery?
No.
Did that concern you when you learned that?
Yeah, my concern was, right at the outside of the gate, I learned that Pointer and Weeks had referred the case to Megaro and Scott Bretschneider, and that they're immediately being paid out of loan money right away. That was a concern about, that arrangement that was going on.
All right, let's take a look at exhibit 153. And if you'll scroll down to the bottom so we can start at the email that starts it. Yep, there it is. Can you see that, Mr. Tarleton? It's an email from May 12th, 2017 from you to Mr. Megaro that says, not sure if this is in the stuff you have sent, but what are the insurance policy limits in play for the defendants who are settling?
Yes.
Okay. Do you recall sending that email?
Yes, I did.
Why did you ask Mr. Megaro what the insurance limits were?
Well, there was a proposed settlement for Red Springs to sort of evaluate, an attempt to start evaluating the propriety of that settlement. And to me, based on some initial due diligence on my end, what are the policy limits? How much money is potentially on the table out there? And I saw it as from the liability side, if you have to prove civil rights violations, this seemed to be a strong case against everybody. Or it didn't seem, it was. It is. And so, how much money is actually out there?
And if we could scroll up on this, do you recall the defendant's response to that email?
The gist of it that I took away was, I think right at the beginning, I was told nobody's really sure, not even the insurers themselves.
Did that concern you as Henry's guardian?
It did. Based on some due diligence I had done, my understanding is that in some ways the easier part of a 1983 civil rights litigation is proving that constitutional rights are violated, and the more difficult legal part can be chasing down how to actually collect the money and complicated legal issues with insurance coverage. And and sometimes lawyers have to bring in lawyers that are kind of have specialties or expertise in that area, like our new team ultimately did in this case.
Yeah, could you talk a bit about what your new team did to try and help Henry in this regard?
You know, one thing brought in Bonnie Wire, who has extensive experience litigating complicated municipal insurance issues, and ultimately determined, you know, different sort of tiers of almost what should be indisputable coverage, and then what's or maybe debatable coverages for a later DEC action or declaratory judgment action. You know, and also I guess we learned that no declaratory judgment action had actually been pursued either on insurance issues, as well as no asset discovery had been performed on you know, the town of Red Springs, because based on my independent due diligence, Red Springs had exposed, unlike the state that is capped out of its own pocket by statute, Red Springs, their own assets were in play on top of whatever insurance might be out there for them.
So let's look at the defendant's deposition. It's Exhibit 100, page 263. Scroll down. Right there. You see there, Mr. Charlton, I don't know if you can see that, but I asked the defendant on line 15 of page 263 of his deposition if he served the town of Red Springs with discovery requests to determine their assets and liabilities. He indicated no, and that it was premature. Why do you, as Henry's guardian, believe that doing that asset discovery was important?
Well, if you're going to settle with them, you want to, one thing you want to try to ensure is, are you cutting the deepest pocket loose early on? This is a complicated area of law. Another is, I mean, if you're going to, you want to lock down as much money for your client as possible, especially when their futures are uncertain. Are they going to need long-term care? You know, there's all kinds of issues with, you got to figure out the valuation of the case and then what's actually potentially collectible.
And have Henry's new attorneys taken steps to reopen discovery in this case?
Yes, they did. After the Judge Boyle denied the civil defendant's motions for summary judgment, they took an interlocutory appeal to the Fourth Circuit Court of Appeals and then to the U.S. Supreme Court on qualified immunity grounds. All of that was ultimately denied, and when it came back from the appellate court, our new legal team moved to reopen, amend the scheduling order, and substitute in new experts.
What did the case against Red Springs eventually settle for after the defendant was removed?
It was $500,000 to each brother, which is roughly, you know, $15,000 per year, I believe, for each year of wrongful incarceration. I may be off on that. It sticks in my mind based on my, you know, initial work on the case.
Okay, and why did it settle for that amount? Why did it settle for that amount?
That's what they were willing to offer, and you know, that's and there's this narrative being floated that the insurance issue was undetermined, and there are other issues that I think Megaro was raising on why it was a good settlement, and you know, my concern was it seemed, yeah.
When did it settle? Was that when Mr. Megaro was still Henry's attorney, or was that after he had been?
Yeah, yeah, when he was still Henry's, well, when he was effectively my attorney at that point, but yeah, when he was still representing the interests of Henry McCollum. Okay. Still in late 2017, I believe, is when the judge approved the Red Springs settlement, proposed settlement.
Okay, and were there external pressures to settle that case? I'm thinking specifically of, did Henry have some issues that he needed to settle the case for?
Well, he was living off of Social Security disability, and which isn't a lot of money, and he didn't have any other assets, and he had creditors coming at him, or purported creditors.
Was this before or after Mr. McCollum, Henry had received the money from the Industrial Commission?
This is after he had received money from the Industrial Commission.
Do you think if Henry had had a guardian that would have helped him not blow through that money from the Industrial Commission, that there would not have been as much pressure to settle with the town of Red Springs at that time?
Well, yeah, if you just kind of look by analogy at what happened with the Red Springs money that came in, all of that, I did due diligence and determined that Henry needed, since he was living in Virginia, what's called a general guardian to oversee his financial affairs. And that in Virginia, they call that a conservator. And we were put in touch with Kimberly Pinchbeck out of Richmond, Virginia, that has some enormous amount of experience in that area and has a fiduciary role with the state of Virginia in connection with conservatorships. And ultimately there was a court hearing where a temporary guardian ad litem petitioned, and I had standing in Virginia based on my guardian ad litem status in this litigation. So that temporary guardian ad litem petitioned for a conservator appointment, and ultimately the court appointed in Virginia Kimberly Pinchbeck. And Kimberly Pinchbeck created a special needs trust, and that's where the $500,000 Red Springs money went into that, which by being structured in a special needs trust overseen by Pinchbeck, who had a $500,000 corporate fiduciary surety bond for an added layer of protection, then Henry was still eligible to receive, to not be disqualified from government benefits, I guess, including Social Security, disability, and then Medicaid.
All right, let's look back at Exhibit 105. Could you just real quick remind the panel what Exhibit 105 is?
That appears to be the fee agreement with Megaro's firm for the civil case.
And let's take a look at page 4. And if you would read the section 3 entitled Costs and Expenses, please, Mr. Tarleton.
It's often necessary for us to incur expenses for items such as travel, lodging, meals, telephone calls, transcription, and the like. Similarly, some matters require substantial amounts of costly ancillary services such as photocopying, messenger delivery services, computerized legal research. HM agrees to advance all such costs and expenses incurred in connection with the matter, including but not limited to photocopying, messenger delivery services, expert witnesses, court reporter fees, computerized research, travel, including mileage, parking, airfare, lodging, meals, and ground transportation, long distance telephone calls, telecopying, court costs, filing fees, and other similar expenses.
That's fine. Thank you, Mr. Tarleton. Based on your experience as Henry's guardian and just reading this document, does HM stand for Henry McCollum or Hal Scott Megaro?
Hal Scott Megaro.
Okay, so based on that paragraph of the contract that Henry and Leon signed with Mr. Megaro, who was to pay for the costs and expenses of the litigation up front?
The Megaro's firm.
Okay, and are expert witness expenses specifically listed in this paragraph as a cost
Yes.
that the defendant's firm was to pay in advance?
Yes.
Okay, let's look at Exhibit 121. Page 2. What is Exhibit 121, Mr. Tarleton?
This appears to be a copy of the sort of breakdown of what happened to the Industrial Commission money.
And what is the fourth deduction from the Industrial Commission award to Henry listed here as an even $10,000?
$10,000 is to be held in escrow for future lawsuit expenses, expert witnesses, etc.
Based on your interactions with Mr. Megaro and with Henry, was that money deducted from Henry's Industrial Commission award for the costs of the expert witnesses in the civil case?
Yes.
So were those expert witnesses for the Industrial Commission?
No.
Okay. Let's look at what actually happened with that money. If we could go back to Exhibit 100, the defendant's deposition. and specifically page 118. And scroll down to the bottom. Okay, so we're talking about here, Mr. Tarleton, what happened to that $10,000. I don't know if you can see that there.
It appears that it was described as going with future lawsuit expenses, not a future lawsuit.
Okay.
There was also already a lawsuit.
That's fine. And if we could look at the bottom of page 119, just one more as we continued talking about it. There, lines 19 through 22, I asked, did you end up spending any portion of it on costs? And he said 4,000 was sent to Dr. Harbin. So is it your understanding, based on what we just read and your experience as Henry's guardian, that some of that money, at least $4,000 of it, did in fact end up going toward the costs of the civil lawsuit?
Yes.
And is that consistent with the contract Henry signed with the defendant?
No, the purported contract had the financial kind of burden of advancing costs on the law firm, which, you know, helps support a contingency fee. And that what had happened, from my perspective, is the financial risk had been shifted back to Henry.
As Henry's guardian, were you concerned about Henry paying those costs instead of the defendant's firm, even though he signed this Exhibit 121, the settlement breakdown?
Can you repeat the question?
Sure. Let's look at Exhibit 121, again, the settlement breakdown. Notwithstanding the fact that Henry received this, and I believe signed it, if we want to scroll to the bottom, explaining where all this money was going, were you concerned as Henry's guardian about that $10,000 being taken out of the Industrial Commission funds for the civil lawsuit?
Yes.
Why?
That under my understanding of contingency fee agreements is that the law firm advances the litigation costs to, in part, to help justify their right to a percentage of a recovery instead of an hourly rate. And
based on your personal experience as Henry's guardian, do you believe Henry understood that he didn't have to give that $10,000 to the defendant?
no,
Why not?
I don't think he understood like this, from my perspective.
If I
What
may I
what is the
respond?
basis for your understanding?
If you could tell us the basis for your understanding of whether or not Henry understood, whether or not you believe Henry understood this agreement.
Right. Meeting Henry, talking with him, reading about the history of his intellectual disability, Dr. Corbin's evaluation of him, all of the other doctors that had evaluated him over the years, and the claims in the case that if even under one of Dr. Harbin's earlier reports that if Henry, effectively didn't understand what was going on in the interview room and what he was really signing and admitting to back when he was interrogated in 1983. All that.
Oh, sorry. Let's look at Exhibit 705. If you'll scroll down there, Brittany, hold on. More. Okay, if you see there, Mr. Tarleton, paragraph 7, this affidavit from a psychologist who evaluated Henry indicates that Henry scored in the lowest 0.6% of the population on the reading and arithmetic portions of the test. Based on your experience as Henry's guardian, do you believe that's an accurate result?
Yes.
And do you believe Henry would need skills in arithmetic and reading to understand a settlement breakdown of $750,000?
Yes, I do.
Let's also look at Exhibit 116. Page 10. Mr. Tarleton, have you seen Exhibit 116 before?
Yes.
Okay, is this a pleading that the defendant filed?
Yes, Megaro, yes.
Okay. If you'll look at the end of paragraph 35, I'm going to read a portion to you if you can see it. It says both brothers need assistance with budgeting their monthly allowance because they are unable to understand the concept of paying utility bills and making purchases. One thing is clear, neither Leon Brown nor Henry Lee McCollum have a concept of budgeting or spending limits, nor do they have any experience in managing money, let alone large sums of money. Would you agree with the defendant's statement in that pleading that Henry struggles to understand the concept of making purchases, particularly large purchases?
Absolutely.
And would that include $10,000 for expert witnesses and costs of a lawsuit?
Yes.
Okay, let's look at Exhibit 150. Mr. Tarleton, have you seen Exhibit 150 before?
If you could scroll down some.
Sure.
I believe this is the proposed settlement with Red Springs filed with the federal court in the federal lawsuit about a month prior, roughly a month or so prior to my appointment as guardian ad litem.
Okay, let's look at page 5 of this PDF and look at specifically the paragraph at the bottom of that page. Keep going. One more. All right, one more. It's paragraph 6. Okay, there we go. Mr. Tarleton, I believe you testified earlier that you do a good bit of federal practice. Is that right?
Yes.
Civil and criminal?
Not a lot in the realm of civil settlements. Like the civil litigation is more with civil commitment hearings.
Well, as either from your experience practicing in federal court or just your understanding from your service as Henry's guardian, do you know what the purpose is of local rule 17.1B3?
Yeah, going back, yeah, when I started doing my due diligence after my appointment, what I realized is that court oversight and approval has to take place whenever anyone is considered either a minor or incompetent to settle up a case in federal court. And so Leon had ultimately, he had wound up in a hospital and things, my understanding. So he had several different guardians, or at least 2. And that's, my understanding was that was why this had to be filed with the court.
And is it your understanding as Henry's guardian that the defendant had already been paid for Roman numerals I and II here listed in paragraph 6?
That's what I came to learn, yes, and that was my concern.
Okay.
That,
Is it your understanding that it was all one and the same case, or were they 2 different cases, the industrial commission and then the civil suit before?
my recollection was one petition combined for both brothers.
No. Was it one lawsuit or were they 2 separate matters, the industrial commission and the civil lawsuit?
Oh, the industrial commission had taken place in a separate, not even state court, a state administrative hearing in front of the industrial commission.
And when you attempted to find out information about the industrial commission matter as Henry's guardian, did the defendant say that it was all one and the same matter, or did he say that they were separate matters?
Separate matters.
Okay. Let's look at, well, first, I'll just ask you, were you at the hearing regarding Henry's competency before Judge Boyle on September 5th, 2017?
Yes.
Do you remember generally what that hearing was about?
It was about whether the one hearing was about to get a new expert opinion, especially with Megaro's filings declaring Henry actually didn't need a guardian, to have an expert evaluation and submitted to the court, where the court could again revisit the issue ultimately on whether Henry needed a guardian.
Okay.
Or at least I've made a claim for determining the validity of the fee agreement. So there's, I guess, several things going on.
Okay, let me just apologize to the court reporter here. Sometimes, Mr. Tarleton, I don't think you can hear me, and sometimes I don't think I can hear you, so apologize for that. Let's look at Exhibit 160, which is the transcript of that hearing. And specifically, first, were you present at this hearing? I don't know if you can see Exhibit 160 here, the transcript for this hearing. Were you present that day?
Yes.
Okay, let's look at page 15, line 1. The defendant is speaking. He says, I think what we're trying to accomplish here is the determination of whether Henry McCollum is legally competent to manage his own affairs. I believe that he is. Did I read that correctly, Mr. Tarleton?
Yes.
Okay. What contracts or agreements were at issue when this hearing took place? What specifically was the court talking about?
I believe the fee agreement with Megaro's law firm was at issue.
Was the settlement with Red Springs also at issue?
Yeah, that was definitely an issue.
Okay, so were those both at issue, the fee agreement and the settlement with Red Springs?
Yes.
Okay, and is the defendant's claim that we just read here to the court, based on your review of the documents, is that consistent with the defendant's prior claims regarding Henry?
Can you repeat that question?
This claim here that we just read, that he believes Henry McCollum is legally competent to manage his own affairs, was that consistent with prior claims made by the defendant regarding Henry?
Well, it seemed that Megaro had invited the appointment of a guardian at the court hearing prior to my appointment. And then also, there were the claims made when he sought the appointment of a guardian for Leon, that the claims also that were made about Henry's ability to manage his affairs.
Okay, let's go to page 8 of Exhibit 160, line 20. Here, there's a quote from Mr. Megaro. I don't believe that Mr. McCollum needs a general guardian because he has been living on his own and managing his own affairs for close to 3 years now, 2.5 years. If we could just jump back real quickly, Mr. Tarleton, to Exhibit 116, the portion we just read regarding both brothers needing assistance managing their money and being unable to budget or understand spending limits. Which of those two statements do you believe is accurate? That Henry can manage his own affairs on his own, or that he has trouble managing his money and understanding spending limits?
From my perspective, the accurate statement is he has enormous trouble managing his affairs.
And what do you base that on?
Well-documented intellectual disability, what the effects of that as opined on by experts over the years, an industrial commission payout that where 8 months later he's borrowing money at double-digit interest rates compounded every 6 months. Just the totality of all, and what I saw with things of how dependent he was on others to get to effectively function.
And did that include your meetings with him, or are you basing that belief off just the documentations that are present in the case?
While his interests were still being represented by Megaro, I only had one meeting with him directly. After my filing, there's to bring into question the challenge validity of the fee agreement. There really wasn't any interactions with him. I know he was upset that he saw me as standing in the way of getting the Red Springs money, and so everything else was really. Well, there was a court hearing where he testified, not that August hearing. Mr. Megaro called Henry McCollum as a witness, and then also, or called him in his own case about the capacity, ability, and function. And then I asked Ken Rose, who was present, who had part of Henry McCollum's pro bono team over several decades, who knew his history of intellectual disability well, to testify about that. At that, I believe it was the August 2017 hearing. So, and he laid out the case really well, and for why Henry can't effectively manage his own affairs.
All right, let's look at Exhibit 132. All right, if you'll scroll down just to the next page there. Mr. Tarleton, have you seen Exhibit 132 before?
Yes.
What is Exhibit 132?
That appears to be a copy of the loan document surrounding a $50,000 loan Henry obtained in May of 2016, roughly 8 months after the Industrial Commission payout, I believe.
Okay, thank you. And was this just so we can kind of understand the timeline, was this the second loan that Henry had taken for multi-funding?
Yes, there had been, back, I think it was March of 2015, around that time, right at the time that Megaro was hired, or took on the case. The first multi-funding loan for nominally for $100,000 was obtained. My understanding of the trajectory of that one was not all $100,000 was paid out of that loan. Disbursements were made that added up from March or so of 2015 until October of 2015, when the Industrial Commission payout came in. Multi-funding only dispersed maybe roughly $80,000, but then they were repaid out of the Industrial Commission money, I think $110,000.
Okay, let's look at pages 10 and 12 of Exhibit 132, this loan contract. If you'll scroll down, Brittany, just based on your service as Henry's guardian, do you know whose signature that is on page 10 of the loan contract here?
It appears to be Megaro's signature.
Okay, and let's look at page 12 of the loan contract. Again, just going down to the bottom real quick. Again, is it your understanding that's Mr. Megaro's signature?
Yes.
Okay, and what's the title of this page at the very top of the loan contract?
Attorney acknowledgement of explanation of terms to plaintiff of irrevocable lien and assignment to multi-funding.
Okay. Would you please read into the record just the first paragraph of this page of the loan contract, please?
The undersigned attorney for Henry McCollum, hereafter plaintiff, and parentheticals his or her in parenthetical successor and or assigns, acknowledges receipts of the plaintiff's agreement and the agreement to assign proceeds and the irrevocable plaintiff's lien. Attorney agrees to distribute any proceeds of the litigation known as Henry McCollum v. Robinson County, Red Springs Police Department, and the state of North Carolina in accordance with the terms of the agreement signed and notarized by the plaintiff in favor of Multi-Funding Inc. That I have been instructed by the plaintiff to provide sufficient monies or proceeds in the amount of $50,000 plus any greater sum as calculated pursuant to paragraphs 2 to 4 of the disclosure statement of the plaintiff's agreements necessary to satisfy in full the agreement signed by the plaintiffs. This will be paid immediately after attorney fees and any liens defined in Schedule B or which the plaintiff is obligated under law to pay prior to any final distribution to the plaintiff or parentheticals his or her in parenthetical successors and or assigns.
Thank you. And then one final sentence. If you would read the sentence just above the all bolded, or excuse me, all caps paragraph that says, "I hereby consent and agree."
Wait, can you
scroll up a little bit? It's the sentence right above the paragraph that is in all caps. I think we might be able to highlight it. Yeah.
That's it.
If you could read
All
the
right.
sentence for us, please.
Yeah, I hereby consent and agree to fully execute this document to pay Multi-Funding all funds due them at the close of this case before final distribution to the plaintiff or his or her successors and or assigns.
And is this the first time you've read this agreement, Mr. Tarleton?
No, I've read it before.
And did it concern you when you first read it as Henry's guardian?
Yes.
Why?
I don't think, from my perspective, I don't see how Henry would understand and contemplate this and seem to be at odds with claims about his capacity in the complaint and lawsuit itself.
If we can go back up to the first page of this contract, I was remiss not to note what the amount is for and what the interest rate is for. Do you see that there, Mr. Tarleton? How much was being loaned and what was the interest rate?
$50,000 on this one, and the interest rate was 18%. every 6 months or part thereof compounded
And how
Yeah.
much was the application fee?
$3,000.
Let's turn to Exhibit 135. And a few pages down. Right there, that email sent from multifunding to Mr. Megaro from May 12th, 2016 at 12:04 PM. How does multifunding refer to the exhibit we just looked at? What do they call it?
They referred to it as signed contract for Henry McCullum, and then ask Megaro to sign it on several pages and return it to them.
Okay, and were you aware that on September 24th of 2019, the State Bar took the deposition of Joseph Duffy of multifunding?
Yes.
Okay, let's look at Exhibit 400. Page 35. Bear with us, Mr. Talton. I apologize, Mr. Duffy. We're in some technology issues, which I'm confident are my fault. There we go. And yeah, if we could look at page 35 of Exhibit 400, line 17. Mr. Talton, can you see that?
Yes.
Okay, I asked Mr. Duffy from multifunding if Mr. Megaro needed to sign that page of the loan contract. He said yes. Without his signature on this page, it would not have proceeded. Based on your experience and review of these documents and your experience as Henry's guardian, is Mr. Duffy's testimony there consistent with your understanding that these needed to be signed for them to be issued?
Yes.
Okay. Let's look at page 36, line 23. Okay. And here I asked Mr. Duffy from multifunding if page 12 that we just looked at with Mr. Megaro's signature and that you just read portions of was part of the loan contract, and he said yes, it is. Based on your review of the documents and your experience as Henry's guardian, is your understanding consistent with Mr. Duffy's testimony there?
Yes.
Okay, and then finally, if we could look at page 37, line 20. Okay, and Mr. Charlton, it says there, I asked, is it your position that by signing this, Mr. Megaro is agreeing to repay the loan prior to paying the plaintiff? And Mr. Megaro said, or excuse me, Mr. Duffy said yes. Based on your experience as Henry's guardian, is Mr. Duffy's testimony here consistent with what you've learned?
Yes.
Did you come to understand what role the defendant played, the defendant being Mr. Megaro, played in these loans?
Yeah, my understanding is that he and his firm, helped pitch the case to multifunding to show them why it's, worthy of advancing funds in advance of, an expected recovery either through settlement or verdict, and that he would have effectively agree to not distribute, a significant amount of any settlement or verdict until multifunding was paid off, and that he was representing that he had explained everything and that his client understood everything, and which was all essential, I guess, to the multifunding's underwriting process.
And as Henry's guardian, did those claims and those portions of the contract concern you?
Yeah, it seemed at odds with the theory in the complaint that he's intellectually disabled and didn't understand what he was agreeing to with the and comprehend everything that was going on in the interview room. And
Are you talking about
it's part of the
coerced into signing a confession? Is that what you mean by the interview room?
Yeah, exactly. Yeah. And also damages later on, ability to function. How much are you going to need for future care and things like that? I mean,
Explain that to me. How could these contracts concern the analysis of future damages?
I mean, if you can understand all of this, if you can really understand all of this, you're probably able to manage your affairs, and you're not going to need a lot of outside assistance in life with, especially with financial matters and, everything you got to do in life to exist in the world. And so there's, to me, it was irreconcilable.
And based on your experience as Henry's guardian, do you believe he understood these contracts that he signed with multi-funding?
I don't believe he understood them at all. I don't think he ever read them.
And are there any lingering effects of these loans? Have they been paid back? What's the status there?
The $50,000 loan and the $15,000 loan have not been paid back. I think multi-funding has retained counsel. They haven't filed suit, but I think they've retained, actually, they let go of some lawyers they hired originally and then hired another law firm recently. So they're still out there, and this is still an unresolved issue. Although I think Judge Boyle, I raised the issue when Judge Boyle, after he approved the Red Spring settlement, stood up to ask, but there's also liens out there, and I think the court made some comment like, I'm not enforcing any liens. But without the transcript, I can't say exactly how that all went down.
And when you say they've retained counsel at multi-funding, is that counsel in New York or is that counsel in North Carolina?
In North Carolina.
Let's look at Exhibit 141. Okay, if you'll scroll up right there. Do you see the email that Mr. Megaro sent to multi-funding there, Mr. Tarleton?
Yes.
Okay, if you would, please read that into the record.
Well, starting at the
At Hi Joe from October 20, 2016.
Yeah. Hi, Joe. Just giving you an update. We have a mediation scheduled for 12/1/2016. We are going to make a concerted effort to settle with at least some of the defendants on that date. Henry is looking for another loan of $40,000. He needs to buy a new car. Is there anything I can do to help with this request?
Had you seen this email prior to today, Mr. Tarleton?
I have.
Were you concerned by it?
Yes. The concern is you're telling a creditor, about a concerted effort to settle with other defendants. That's also possibly in the creditor's interest is not to maximize, the amount that it settles for. They just want to be repaid at all their interest. And, and they don't have any, obligations to keep things confidential as far as I could tell.
And is the desire and design to settle a case something that's confidential client information?
I think so.
And as Henry's guardian, do you see any benefit for Henry for that confidential client information being shared with one of his creditors?
No.
Let's turn back to Exhibit 121 and look at page 2 of Exhibit 121. You're fine. It's okay. Give us just 1 second, Mr. Tarleton. At least your background's not something embarrassing, Dog has actually bit me before. True story. Is this Exhibit 121? Sharing is paused. It says bring your shared window to the front. I apologize, members of the panel, from a technology issue here.
You may need to stop share and reshare again to make it work.
I'm not competent to do this. Good job. Okay. Can you see that, Mr. Tarleton?
Yes.
Okay. And just remind the panel what Exhibit 121 is.
This appears to be a letter on October 21st of 2015 that lays out the breakdown on the Industrial Commission award to the Henry and Leon.
Okay, and what's the third deduction here for $11,000, $11,637.57?
I think that was for purported advances.
Okay, and what does it say next to total advances?
It says see spreadsheet for that number.
Turn to that spreadsheet. It's on page 7 of Exhibit 121. Can you see that, Mr. Tarleton? I know it's rather small.
Yes, I did.
Okay, and it appears that there are 2 sections for advances, one starting in March of 2015 and then ending in October of 2015. Do you see that?
Yeah.
Okay. As Henry's guardian, do you know what these advances were for?
I mean, the appearance to me, and based on, you know, some a little bit of information I learned, that just money was being given to Henry to live for just general living expenses from the law firm.
Is that permitted under the North Carolina Rules of Professional Conduct?
Yes, that's my understanding of the rules.
Can you give a client money for living expenses?
You're not supposed to become your client's creditor.
Why is that?
You know, objectivity. My understanding, roughly, you know, objectivity. You're not supposed to just create a situation where you might be buying loyalty or dependence.
And is Henry easily manipulated by money?
I think so.
Have you seen a receipt for any of these advances?
No.
And do you know if all of them were for litigation expenses or if they were for, you know, just spending money?
It appears to be more for what would be characterized as personal expenses to Henry, not the things that were outlined in a separate category of you know, costs for litigation, like just cash, Western Union, you know, a hotel stay for a vacation.
So we learned yesterday or went over yesterday that the deposit of the Industrial Commission funds was made on October 13th. So if you just want to look prior to October 13th, as your experience as Henry's guardian, do you have any understanding as to what these resort fees in Orlando would have been?
My understanding is they actually went to Megaro's office in Orlando to get the Industrial Commission money, and as a part of that, you know, they stayed in Disneyland down there and brought, like, you know, a large family entourage.
And is that a litigation expense?
Oh, that doesn't seem to be.
Okay. Let's move on to the affidavit regarding the loans that we've talked about. Mr. Tarleton, do you need to look back at Exhibit 132, the loan documents that Mr. Megaro signed and that you just read from, or are those enough in your memory?
Yeah, please pull it up for a second.
Okay, sure. Let's look at Exhibit 132 and then go to the signature pages again.
Okay. Yeah.
And then specifically page 12. And do you recall the portion that you read just slightly up where the signee says, "I hereby consent and agree to fully execute this document and to pay multi-funding all funds due them at the close of this case"? Do you see that?
Yeah.
And is it your understanding, just from your experience as Henry's guardian, that the defendant didn't sign just this one, he signed a few of these?
Yeah, there was this Megaro sign, not Henry.
Right. And based on Exhibit 135, which we looked at and can pull up again, did multi-funding ask the defendant to sign those contracts before the loans were funded?
Did they ask who?
Did they ask Mr. Megaro to sign those contracts before the loans were funded?
Yes, they did.
Okay. Did the defendant's involvement in the loan process come up during Judge Boyle's consideration of the settlement proposal and your subsequent appointment as Henry's guardian?
It was in the loans were, I raised concerns with them in my filing in July of 2017 with the court over the fee agreement and other related issues with the representation. And I can't remember
Is that
in
exhibit
all detail.
156?
Yeah,
Sorry, is that exhibit 156 that we started out looking at?
I believe so.
Okay, if we could go back to exhibit 156, please. Okay, and then the concern where you mention the loans, I believe, is the third or fourth one. Looks like the third one here. So did you bring that up to Judge Boyle then in this pleading?
I believe my recollection, one way it may have come out different ways. One recollection I think I have is Dr. Harvin giving an opinion that he expressly said that I think that August 2017 hearing that he was not giving an opinion about whether Henry had capacity to manage his own affairs under the standard for competency in a civil case. He gave another opinion on a different referral question, as he put it, I think ultimately, whether Henry had capacity to enter into a settlement agreement. And what part of the analysis issue was like, well, effective ability to manage affairs still. And I believe we had cross-examination on the sort of the history of the loan, like what happened. Industrial Commission loan comes in 8 months later, he's borrowing money at this interest rate, what seemed to be predatory interest rate. Like all that was being aired out. I can't remember exactly what all Judge Boyle went into about it, or whether he did it all at that hearing, frankly.
And what's the date on this exhibit 156? Maybe we can either scroll to the bottom or the top. It might be the top.
Well, the date on this filing in federal timestamps or date stamp CMECF is, I think, July 26th of 2017.
Okay. And let's look at exhibit 662, which is a few months later, still in 2017. Have you seen this exhibit before, Mr. Tarleton?
I have.
Okay, and if you would just read it into the record, please, this email from Patrick Megaro to Multifunding.
Attached is a draft affidavit for Joe Duffy. I was really hoping he could give live witness testimony today. Without it, I'm at a disadvantage. I went through the facts with him last night and prepped him to testify for a while. Please take a look and let me know what you think. The affidavit is based on our conversations, recollection, and emails exchange. I will send this to Joe also.
Okay, and have you seen that affidavit that was attached and eventually executed?
I have.
Okay, let's take a look at that. It's exhibit 189. And let's turn to page 3 of exhibit 189 and look at paragraphs 11, 12, and 13. Can you see paragraph 11, Mr. Tarleton?
Yes.
If you would please, sir, read that into the record.
Neither Mr. Megaro nor anyone from his office ever entered into any agreement with Multifunding with respect to any advances extended to either Mr. McCollum, Mr. Brown, or Geraldine Brown.
That's fine. Thank you, Mr. Tarleton. Based on your service as Henry's guardian and even just the documents that we've looked at today, is that paragraph accurate?
No.
Why not?
That Megaro and his firm had integral involvement in obtaining the loans, were but for causes of those loans, signed off on them, claimed that they explained everything to Henry. Leon agreed to, I think the loans called for liens on the case.
Okay, well, that's a good segue into paragraph 12. If you can see that as well, would you please read it? into evidence, paragraph 12.
Yes, neither Mr. Megaro nor anyone from his office ever gave multi-funding a lien on any recovery for Mr. McCollum or Mr. Brown. The liens were signed by the clients. Mr. Megaro simply acknowledged the existence of a lien.
Based on your service as Henry's guardian and just your review of the documents that we've seen today, is that paragraph accurate?
No,
Okay, let's also read, if you would, please, paragraph 12, paragraph 13.
under which 13 you said?
Please read 13. And do you need it to be higher up on the page? We can, I think, do that.
Please. In 2016, Mr. McCollum contacted me directly and requested additional advances. This is common with typo client, our clients. Anyway, approximately 80% of our clients request additional advances after their first. In these subsequent advances, again, Mr. Megaro is not involved in these transactions except to acknowledge the existence of the liens Mr. McCollum granted to multi-funding as a result of the advances.
That's fine, Mr. Trotter, thank you. That's fine, just for the sake of time. Based on your service as Henry's guardian and your review of the documents we've seen today, is it accurate to say that the defendant was not involved in the loan process except to acknowledge the existence of the liens?
No.
Why do you say no?
Again, going back to that, they had to write up. My understanding is they had to write up and pitch the value and and strength and merits of the case. That the majority of communications were running through Megaro with multi-funding. That that he was acknowledging that there's a priority on any payouts that come in, going to making an agreement that multi-funding would have priority on money that comes into the firm from the case settlements or verdicts, things of that nature that we've discussed.
Oh, I'm sorry. Thought you were finished.
Yeah, sorry.
You indicated that you said most of the communications were through Mr. Megaro. Are you saying that just based on your review of the documents you've received and in your position as Henry's guardian?
Yes, things I've reviewed in my position, yes.
Did that include emails between Mr. Megaro and multi-funding?
Yes.
Did you see many emails wherein your client, or excuse me, your ward was copied?
Never one.
Let's look at the defendant's deposition, page 26. Line 16.
Exhibit, please.
Exhibit 100. Apologize. Mr. Tarleton, can you see that?
Yes.
And I asked Mr. Megaro if the affidavit that we just looked at was for his benefit or his client's benefit. And he says it was more for the client's benefit. As Henry's guardian, can you think of any benefit that this affidavit would give to him?
It seemed to be protecting Mr. Megaro from, any claims that it was protecting Mr. Megaro from any claims that he might have an obligation if Henry didn't pay off those loans.
And in that civil case, would it potentially harm Henry's interests for an affidavit to be presented, an argument to be made that he could go and get these loans on his own and understand their terms on his own?
Yes.
How could that harm Henry?
What's that?
How could that argument harm Henry?
In the civil case, claims are simultaneously being said that he didn't understand the purported confessions that law enforcement were writing out, that to this day he doesn't understand Miranda rights. Claims like that being submitted by his own expert. I mean, and then again, into the damages. Part of the idea is the ability to function in the world and what assistance you're going to need in life. All of that is harmed by, claims that any other, like a simultaneous claim here that you can understand fairly complicated financial transactions. all these various rights and obligations.
Okay, I'm almost done, I promise. Let's just look at
Yeah.
a couple more exhibits here, Mr. Charlton.
Yeah.
Have you seen, we're showing you now exhibit 145. Have you seen this before?
Yes, I have.
Okay, let's scroll down to, I believe it's page 50. Reserves. Keep going down. I'll tell you when to stop. Go to the mental retardation. Okay. You said you have seen this PowerPoint presentation before?
I have. It was in a large amount of material sent to me from Megaro's firm early on in the case.
Okay, and based just on my counting, and I think my paralegal can just slowly scroll through just one page at a time here. There are over 30 pages essentially entitled Evidence of Mental Retardation or the legal standard of mental retardation. Do you know why there are so many slides on this PowerPoint created by the defendant and presented by him that refer to Henry's mental retardation?
I think right before the first slide that introduces what's styled as mental retardation, or now we call it intellectual disability, I think it deals with one of the key due process claims, how his due process rights were violated by, being coerced and manipulated into a false, purported confession, false confession, however you want to frame it.
Was his inability to understand that confession a big part of his case?
Yeah, it's a critical part of this case, of the civil rights lawsuit.
And what evidence would you submit to show that Henry couldn't understand that confession?
The diagnosed with intellectual disability, or back then mental retardation, repeatedly over the years is very significant evidence.
So that was important to Henry's case?
Absolutely.
Okay, let's look at Dr. Harbin's initial report in July of 2016, Exhibit 643. And this is before the court called into question the retainer agreement. Have you seen this report before of Dr. Harbin from July of 2016?
Yes, I have.
Okay, if you want to just scroll to the meat of it there, Brittany. Keep going. Dr. Harbin, the defendant's expert actually in this disciplinary proceeding, notes that Dr. Richard Rumer, PhD, on November 18th of 1991, concluded that the statement Henry gave to the police was well above his level of literacy. As Henry's guardian, do you agree with that conclusion?
Say that one more time.
The conclusion that the statement or the confession Henry allegedly gave to the police was well above his level of literacy.
Yes, I agree with that.
Dr. Harbin also notes in his report that Dr. Helen Rogers, PhD, evaluated Henry and found that he was mentally retarded. Do you agree with that?
Yes.
Dr. Harbin also notes that Dr. Rogers opined that Henry likely had PTSD and was unlikely to comprehend the principles and strategies of his defense and unable to follow the progress of his trial. As Henry's guardian, do you agree with that conclusion?
Yes.
Okay. Dr. Harbin also notes in his report that Dr. Helen Rogers further stated that Henry's decision-making was severely impaired and that he is not capable of weighing the consequences of his choices and is susceptible to leading questions. As Henry's guardian, do you agree with that conclusion?
Yes.
Dr. Harbin also cites sources in his report noting that Henry suffers from impaired verbal comprehension, depression, anxiety, and that Henry is highly suggestible. As Henry's guardian, do you agree with that conclusion?
Yes.
The report also cites Dr. George Baroff, who found that Henry was mentally retarded and had difficulty with verbal comprehension, such that Henry could not have knowingly waived his Miranda rights. Would you agree with that conclusion?
Yes.
Dr. Harbin, and I will spare everyone from reading this, but he also notes quite a bit in his report about the psychological impact of incarceration and indicates, consistent with what Dr. Corvin testified in this hearing today, that the prisonization, and that is the time that Henry spent in prison, would actually have a negative impact on his ability to understand things. Would you agree with that?
Yes.
Do you believe that Henry's intellectual abilities improved while he was in prison, or were they worsened because of his time in prison?
To me, worsened.
Dr. Harbin also noted in his report that Henry will be overly dependent upon others for decision-making, will be overly influenced by others, will lack self-confidence and assertiveness, and will be easily influenced and manipulated by others. As Henry's guardian, do you agree with that conclusion?
Yes.
Dr. Harbin also noted in his report that Henry is unlikely to ever recover significantly from the severe distortions to his development, life skills, and ability to enjoy intimate personal relationships caused by the harsh, dangerous, demeaning, and depersonalizing experiences of his confinement. As Henry's guardian, do you agree with that conclusion?
Yes.
So, Mr. Tarleton, what was the point of all this evidence that was submitted, the over 30 slides in the PowerPoint showing the evidence of mental retardation, this report from Dr. Harbin indicating all the things I just read to you? What was the point of that for Henry's case?
That he didn't understand the confessions that he was coerced into, that they tried to coerce him into signing, that which means his civil rights were violated, which is sort of the tort, for lack of a better word. That's fault, it's liability, and it goes to damages as well. Just sort of the main components of that civil case.
As Henry's guardian, were you concerned about the defendants, that's Mr. Megaro's, extensive arguments that Henry was competent?
Yes.
Why?
It was undermining the claims in the civil case for liability and damages.
How so? What were those claims in the civil case, and what did they have to do with Henry's mental deficiencies?
That he couldn't understand the confessions, or the confession that he was coerced into signing, that the confession was the case. There wasn't physical evidence to tie him to the a crime scene, that there was conflicts within his own interview with the crime scene and between him and his brother's interviews, and ultimately innocence established 31 years later by a serial killer with the same MOs, DNA being found on a cigarette butt at the crime scene. And so you go back to the totality of this intellectual disability is key to understanding how a innocent person's civil rights were violated and how they wound up wrongfully incarcerated on death row for 31 years. And understanding that too is key to understanding the damages in the case.
So would arguments that the defendant make regarding Henry's alleged competency be harmful to Henry?
The more you play up competency, the more you're undermining the liability claims and damage claims.
Looking back at Exhibit 160, line 8, the court brings up, I believe, that same concern regarding the conflict of interest when the court said, and if you can see this, Mr. Tarleton, the court said, do you think you have a professional conflict of interest with your client at this point? Mr. Megaro said, not at all, not at all. The court said, uh-huh. Mr. Megaro said, I have no conflict of interest. The court said, uh-huh. Did you share that concern that there was a conflict of interest between Mr. Megaro's arguments he was making and Henry's interests?
Absolutely, definitely. The case was being undermined, and that I developed a concern that the motivation for that, from my perspective, was to protect money collected and to try to not be responsible for money borrowed. And there could be claims that Henry could bring if he would ever get a general, guardian, or conservator to try to recoup some of that from this person who's supposed to be representing his best interest in the civil litigation.
And just we've seen this page before, but on page 15 of Exhibit 160, the defendant indicates that he believes Henry is competent to manage his own affairs. Obviously, that's just a very short portion of this entire transcript. For the sake of time, we're not going to read the whole thing. But is that a good summation of what the defendant argued that day to the court, that he believed Henry was competent to manage his own affairs?
That's right.
And did he present an expert to give testimony that day as well?
Yes, I believe that was, Dr. Harbin was presented that day.
And was that examination of that expert for the purpose of showing that Henry was competent or that he was incompetent?
Well, Dr. Harbin, under cross-examination, clarified that he was not actually asked to opine on the forensic legal question of competency for a civil case, that he was asked to, in his professional view, opine on a distinct question about the capability of entering into a settlement agreement.
Thank you. And then if we could look at Exhibit 157. Okay, Mr. Tarleton, can you see that email?
Yes.
Okay, if you would please just read that email into the record.
Okay. Says the case is turned into a wreck. It looks like this is to Dr. Harbin. The guardian appointed for Henry just filed a motion to have the court fire me based on his single 45-minute meeting with Henry and the history of low IQ. In his expert opinion, Henry is incompetent and was incompetent to sign the retainer agreement to hire me as his lawyer and to agree to any settlement. Take a look at this motion. I'm constantly being personally attacked in this case. I now have to defend myself against some very serious allegations of misconduct and have to go to court on August 9th. Would you be able to come give your opinion? I'm speaking to Savannah Pittman this afternoon about the evaluation, but everything looked good to me. I plan to file her petition shortly.
Would you agree with the defendant's statement there that Henry's lack of competence called into question the retainer agreement?
Yeah, Henry's lack of competence did call into question the retainer agreement, yes.
And would you agree that as a result, the defendant was personally attacked?
Yeah, I think my filing raised concerns that if the court found them to be valid, that there's, misconduct going on.
If we could just look real briefly at the defendant's deposition. I believe this is the last exhibit we'll look at, so I'm forecasting we're almost done here. Page 83 of Exhibit 100. Okay, line 15. I asked the defendant why Henry and Leon's IQs mattered. And Mr. Tarleton, could you read his response there, lines 16 through 21?
It says, because just like a civil attorney or a capital defense attorney would want to emphasize the limited intellectual ability, I wanted to emphasize the limited intellectual ability in order to establish the claim that they were wrongfully convicted and coerced into signing false confessions.
So would you agree that Henry and Leon's mental deficiencies were a primary response to the confessions that they signed?
Yes.
So would evidence tending to show that they could understand other documents cut against that claim from Henry and Leon?
Yes, it would cut against it and could bolster the civil defendant's arguments that from the law enforcement perspective, they thought they were legitimate confessions and gave them probable cause to arrest them.
Okay, now, Mr. Tarleton, are you financially motivated to have Henry adjudicated incompetent?
No.
How are you getting paid in this manner?
There's a court order that appoints me that I think contemplates reasonable fees as part of costs of the case. I recall when the judge approved the Red Spring settlement, talking about taxing costs to the civil defendants. But I didn't put in for a fee petition to the court at that point because, frankly, I saw the Red Springs settlement as so low in value that the full amount needed to be in the special needs trust to help protect his well-being to the extent it could for the remainder of the litigation. So I haven't sought to submit a fee application. It ultimately has to be approved by the court.
His being Henry?
What's that?
You said to protect, I think you said to protect his interests, or
right.
Were you talking about
right.
Henry?
The more money he has right now, the less pressure there is to settle the case for less than what it's worth.
So as you sit there today, have you collected a penny from anyone for your service as Henry's guardian?
No.
Okay. Some comments have been made over the past couple days about the defendant not having an opportunity to have Henry evaluated as the state bar did. Let me ask you, has Mr. Megaro or his counsel ever asked you if they could have Henry evaluated?
No,
Have you denied Mr. Megaro or his counsel access to Henry in any
No.
way?
no.
Okay. Some comments have also been made about my presence at the second evaluation by Dr. Corbin of Henry. Do you recall why I had to go to Henry's house in January for his second evaluation with Dr. Corbin?
My recollection is that Dr. Corbin was going to do it remotely with Zoom or, some of these video platforms, and concerned about Henry being able to get it done right, and that you need someone up there to help facilitate that.
Okay. And you and I texted about that, is that correct?
Probably, yeah. That would,
And were you aware that I turned over all of those text messages in Discovery?
my understanding is you have.
Okay. One moment, please. Oh, yes. Thank you, Mr. Murphy. Who does Henry currently own his own house, or is it in an irrevocable trust with oversight?
It's his house is owned by the Special Needs Trust. It's not legally titled in his name.
So Henry didn't go out and buy a house on his own?
No.
Nothing further. Thank you.
Okay, let's take our afternoon break. It's now 3:15. Let's come back about 3:30, please.
I don't know if you heard
Yeah, no,
that.
that's fine. Yeah.
Mr. Tarleton, can you still hear me? We'll get him back.
Yeah, I can. I'm back on. I can hear you.
Okay, we're taking a break until 3:30, okay?
3:30. Okay, I got it. Thank you.
Yeah, I think so, yeah.
Well, that.
I think we may have a few technology things to deal with, yes, sir, before Mr. Williamson begins, so we can get him up there. And then, do you have your documents on a jump drive, or are you not going to show him any documents?
Actually, I think the only ones I want to show him are on yours already.
Okay, do you know which ones they are? So that
132 and 189, that's multi-funding document. I think you referred to that several times. 189 is the Duffy affidavit.
is that the only two?
I think so.
Okay, Brittany, can you get those pulled up? Yeah. What we'll do, Lane, is just,
frugal.
well, yeah, that's fine. We'll pull them up so that you can,
Yeah.
yeah. We'll let you drive, but she can get them pulled up there so that you can get to them.
Appreciate that.
One of her three. At the other Christmas party, that dog bit me. No, that is not true. That is not true. That was the dog. You're victim blaming. That's what you're doing.
There.
Yeah, sure. You want me to?
Yeah.
Okay. Mr. Tarleton, are you still there?
Yes, one sec. Restarting the video, unmuted.
All right, thank you.
I need to raise the camera a bit here. If we go full screen. Am I fully on?
You over the top of your head.
Well, pretend I have
I was going to give
hair.
you the choice about that, Mr. Williamson.
Yeah. Well,
Okay.
yeah, that's fine. That's fine. Get the full impact of my white balding head. Okay, that's cool. Thank you very much. Good afternoon, Mr. Tarleton. Can you hear me okay?
Yes, sir. Good afternoon.
Good afternoon, Mel. I am Lane Williamson. I represent Mr. Megaro in this proceeding. And you and I don't believe have ever met under any circumstances, as far as I know. Is that correct?
I think that's right.
Okay. Now, I've got some questions for you this afternoon. Before Judge Boyle appointed you as guardian ad litem for Henry McCollum, you'd never been a guardian for anyone before. Is that right?
That's right.
Now, as an attorney, how many times had you had your own client adjudicated incompetent, if any?
I've had a federal client, at least 2 adjudicated incompetent. I've had multiple federal clients, by federal client, I mean clients charged in federal criminal cases, go off for competency evaluations. There may be more, just this is going off the top of my head.
Those 2 that you had adjudicated or that were adjudicated incompetent, did they get guardians that were appointed?
Not in a criminal case.
Now, before Judge Boyle appointed you as a guardian ad litem, in this case, you didn't have any experience in handling 1983 litigation, did you?
No, sir.
I'm interested, when did you first speak with Ken Rose regarding Mr. McCollum or this case?
I can't say the exact date, but it was after my appointment, when I started gathering information on the case. I wanted to, what I was very interested in was the theory of the lack of probable cause to arrest and every other claim against the Red Springs defendants in particular. And I wanted Ken Rose's input on what the constitutional violations were as expressly against the Red Springs police officers, the town of Red Springs police officers.
But you don't recall when it was you first had contact with Mr. Rose about this case?
It would have been, I can't tell you specifically, but within,
guess, but you know.
I can't guess.
All right. Did he contact you or did you contact him?
I contacted him.
Now, you talked about how you have not yet submitted a fee application for your services as guardian ad litem. You call that testimony.
That's right.
Are you keeping your time that you spend on this matter?
Yes, sir.
Do you have any understanding as to what you would expect to be paid on an hourly rate when you do submit a fee application?
I don't specifically, but I will say that under the Criminal Justice Act for federal appointed cases, I'm paid at, I think the latest rate now is $155 an hour. Leon Brown's guardian, Dwayne Gilliam, the state, I think, pays him out of Fayetteville at $250 an hour, something like that. So those are some metrics for, guardian fees when lawyers are guardians, I guess.
But at this point, you don't know what your hourly fee will be set at, I take
It would have to be set by Judge Boyle.
Sure. But you have no indication as to what it's going to be. You're just,
no.
Okay. How many hours, if you know, do you have in this matter so far?
It's a lot. You want me to look it up or?
Well, only if you have it at hand. I don't want to spend a lot of time on that, but if you can estimate.
Yeah, just give me a couple seconds.
Sure.
Or a minute, maybe.
Thank you.
since May of 2017, I probably have about 245 hours in the case, in the matter.
All right. And did you at some point ask Neil Yarborough, the town attorney for Red Springs, if you could get paid for your services out of the Red Springs settlement money?
No, I did not ask him that.
When was the last time you saw Henry McCollum in person?
It was probably right before the pandemic. I was up in Virginia. I went to the Piedmont Regional Jail to visit a client, and then I went over to check in with Henry and discuss things that the new legal team were doing. He's come down to my office multiple times too. Before his uncle passed away, his uncle would drive him down and he would come to my office. And this is after Mr. Megaro is no longer in the case. But anyways, I think it was right before the pandemic is the last time I saw him in person.
Personal. So over a year.
Yes, sir.
Do you recall when, do you speak to him on the phone from time to time?
From time to time. He also talks now directly with the new legal team. And he has a guardian in Virginia, a conservator in Virginia that deals with his special needs trust.
Do you recall when the last time was that you spoke with him on the phone?
I believe I texted with him a week ago.
Does he frequently text or do you call? Voice.
He'll text a lot. And then we'll have calls.
Now, you did petition a Virginia court to have Kimberly Pinchbeck, a lawyer appointed as general guardian for him in early 2018?
Yes, sir.
Okay. You didn't notify Mr. Megaro in advance that you were making that petition, did you?
I don't know. I think he knew that. He knew about it.
You don't recall, though, informing him that you were doing that. Is that fair to say?
I don't recall whether I informed him or not.
Now, she was appointed as a limited general guardian for Henry McCollum by the Virginia court, correct?
Right. Or conservator, or something that label.
Whatever they call it.
Right. Yes, sir.
Do you recall that date?
I believe it was in March of 2018. Maybe the March 26th of 2018 was the appointment order, and then the special needs trust, I think, was created March 28th of 2018.
Right. That's the best of your recollection.
Yes, sir.
Right. Do you understand that she's being compensated for her services as limited
Yep.
guardian?
Yep.
Do you know anything about those arrangements other than she is being compensated?
I can't recall the exact details.
Do you recall who approves those fees for her?
No, I'll be guessing about,
No one wants to guess.
Yeah, well, I'm not, yeah.
Yeah, okay. But you've, even though she's been appointed for whatever that status is, you're still remaining as guardian ad litem in this civil case before Judge Boyle, correct?
That's right.
Now, you were first appointed as guardian ad litem for Mr. McCollum by Judge Boyle on May 10, 2017. Does that sound right?
That does.
And within 24 hours of your appointment, Mr. Megaro called you to introduce himself. You recall that?
That sounds right.
And he offered to meet with you and give you a copy of the case file and discuss the case with you at that time?
That sounds right.
But you did not meet with him until June 21, 2017, more than a month later. Does that sound right?
Well, we talked on the phone, but you're right. He came from Florida and Brett Schneider came from New York. They came into Raleigh and that's when we arranged a meeting at my office, in person meeting.
Do you recall, do you recall whether you had spoken with Ken Rose about this matter before you met with Mr. Megaro at your office on June?
I think I had by June 21st. I'm pretty sure I had.
Now, when you met with Mr. Megaro on June 21st, he gave you a thumb drive with his file on it, didn't he?
I think they had sent stuff by Dropbox, cloud transfer, file transfer. And I think he also gave a thumb drive during that meeting. But I may be wrong about it. Pretty sure there was there was a Dropbox submission, but then there was a thumb drive as well.
So both.
Right, yes, sir.
Do you recall it's fair to say that cumulative between those two, it's several 100,000 pages?
A lot of information, yes, sir.
Now, one of the things you discussed with Mr. Megaro at that June 21, 2017 was the fee agreement that he had. Do you recall that?
Yeah, I recall discussing that, fee agreement.
Do you recall that he offered to amend or redraft that fee agreement?
I think he did.
You didn't ever respond directly to that offer, did you?
I think I was absorbing everything and I wasn't making any final decisions at that point.
But you did ask on July 26th then of 2017, you filed a motion asking the court to determine the retainer agreement and Megaro's representation of McCollum as invalid.
Right, whether to make that determination, yes, sir.
And in that motion, you also submitted, didn't you, that the proposed $1 million settlement with the town of Red Springs was not enough or insufficient?
I think I've raised concerns with it.
Now, before filing that motion, you didn't discuss any of those issues, including the sufficiency of the Red Springs settlement with Mr. Megaro, did you?
Oh, I discussed the sufficiency of it, of the settlement. Yes, sir.
At the time you filed that, did Henry McCollum want Megaro off the case, or had he expressed to you that he wanted Megaro off the case?
He wanted Megaro, but he wanted that Red Springs money.
And well, on August 10, 2017, Henry McCollum testified at the hearing before Judge Boyle that he did not need a guardian.
Yes, sir.
And he also testified that he wanted Megaro to stay on the case because he knew his case better than anyone. You recall that?
I did.
Now, I tell you, there's no way that before you filed your motion on July 26th that you had read the entire case file for Henry McCollum.
Not the entire case file.
And I assume that's fair to say you hadn't read the entire case file by today that Mr. Megaro gave you.
Wait, the entire one by today? No, I rely on the lawyers for a lot of things. It helps keep the hours down,
Now, before you filed that motion, what independent investigation had you done into the town of Red Springs finances, if any?
I had not done anything, neither had Megaro. Formally, I guess you could say.
You say neither had Megaro. Did you see in what he turned over to you, he had those insurance policies for the years prior to 1983 and the years afterward?
He had Rule 26 disclosures, but he had told us that that no one knew the insurance coverage. It was, ultimately unknown.
Well, you knew, based upon what Mr. Megaro told you, that there appeared to be a gap in the insurance for 1983.
I was never given any meaningful analysis of the insurance issues from your client.
And you knew from what the file material he gave you is that even if there were insurance, there was a $250,000 limit.
No, I think he said that there could be maybe 1.25 million in coverage, but we saw the email early on. That's essentially the net result that he told me, that no one really knows what the coverage is.
And you knew from a review of the policies that were in effect before and after 1983 that there was an exclusion for intentional tort, so that there was a substantial question as to whether, even if there was a policy in effect, that it would cover this type of claim.
I'm not an insurance specialist. I don't know that.
Did you know that the town of Red Springs in the civil case was defending under a reservation of rights?
Yeah, I did. I understood that concept.
At what point, if ever, did you make an investigation personally into the state of the town of Red Springs finances?
Through our new lawyers, we've done a lot of due diligence into that.
Are you aware that if you looked at the publicly available budget for Red Springs, that the amount of ad valorem taxes that they collect in any one year is less than that $1 million settlement?
I'm not aware of that.
It's publicly, well, all right. Getting back to the status of the case at the time that you made this motion, you knew that Megaro had filed a motion for summary judgment for the plaintiffs. Do you know that was pending?
Yes, sir.
Okay. And had you reviewed all 12,800 pages of that motion?
No, sir.
But you knew it was 12,800 pages, or at least very extensive?
I knew it was a lot.
Okay. And you knew that Megaro at that point had conducted numerous depositions in the case?
Yes, sir.
And you knew that for some of those, the defendants had been deposed for the limit of 8 hours each?
I can't say I knew the hours, but I knew there were multiple depositions that had been conducted and that they were lengthy.
Well, you knew that Mr. Megaro was pursuing the case aggressively until he was stopped.
Yeah, it was, he in certain respects, absolutely.
And did you also know that after Mr. Megaro filed his motion for summary judgment, the defendants filed their motions for summary judgment?
Yeah, I think that's right. And there were cross motions for summary judgment.
And you also knew that at that point, Mr. Megaro had filed opposition to those, to the defendants' motions for summary judgment.
Well, that sounds right.
And you knew that if the summary judgment is denied, really for either side, that the next stage in the civil trial is usually going to be the trial itself.
Well, not in 1983 litigation. You're usually going to have a qualified immunity appeal by the civil defendants.
Well, what I described there was we had summary judgment motions pending. There was a lot of discovery. The case was being aggressively pursued by Mr. Megaro. That was the state when you filed your motion to determine whether the retainer agreement was invalid.
I would dispute that it was aggressive as to the town of Red Springs, but yeah, I mean, there's a lot in your question, but yeah, he was definitely pursuing the case against civil defendants.
Well, and so once you filed your motion, for the next 5 months, there was litigation about Mr. Megaro and whether he would stay in the case. That basically took place then.
I think I would answer that, sir, as litigation whether I would stay in the case. Whether Henry needed a guardian, I think that was the litigation going on. Or the issue for the court.
Well,
Before the case can proceed.
wrapped up in that was the issue of whether Megaro would continue to be counsel for the plaintiffs.
Well, I think the issue was is the validity of the fee agreement and other issues that were floated out of that.
Well, now, getting to the settlement with Red Springs, ultimately, on December 14, 2017, you approved the settlement with the town of Red Springs on the record to Judge Boyle. Not the settlement with any payment, of course, to Mr. Megaro, but the total amount of the settlement. You indicated your approval of that.
I don't recall that, no, sir.
Do you recall on that day that Judge Boyle asked Mr. Megaro for justification as to why the settlement was reasonable?
I do recall that.
And you recall that Mr. Megaro put those reasons on the record?
I did.
And you do recall that Judge Boyle approved the settlement?
I did.
Now, after the settlement with the town of Red Springs, Mr. Megaro argued the motions for summary judgment before Judge Boyle. You aware of that?
Yes, sir.
Okay. And ultimately, Mr. Megaro's argument, he won that argument. The defendant's motions were denied.
That's right.
And so that meant the case was still live, right?
Right, as to the effectively, we can call the remaining groups of defendants the county defendants and then the state defendants, which are the SBI agents.
Right. Now, that order denying the defendant's motions for summary judgment was issued on March 1, 2018. You recall that?
Yeah, I do.
Okay, that was more than 3 years ago.
Right.
And Megaro was terminated as attorney not too long after that on April 25, 2018.
Right, while the case was on appeal, interlocutory appeal over qualified immunity by the remaining civil defendants.
I want to, before I finish up, refer you to a couple of exhibits that were you already were shown. And this would be State Bars, if we could get up number 132.
It's right there on that computer.
What?
You want me to do it for you?
Yeah. Don't trust me with machinery. Thanks so much. And I'm going to ask, well, first on this 132, to show the first page so you recognize it. for sure. Okay. You recognize that exhibit you testified about some earlier today?
Yes, sir.
Okay. Could we go to page 12 of that? Okay. Scroll down a bit, please. Thank you. Okay. Could you, ma'am, could you highlight that last paragraph by execution hereof? Do you see that on your screen, Mr. Tarleton?
I do.
Could you read that?
Yes, sir. By execution hereof, I am solely and only following the instructions of the plaintiff. I've also explained to the plaintiff that I am not endorsing or recommending this agreement or otherwise rendering any legal opinion or legal advice. In connection with the agreement, I make no statements, render no opinion, and proffer no guarantee as it pertains to the possibility of recovery of some or any proceeds as a result of the litigation. By execution hereof, I assume no duties or obligations to multi-funding other than the ministerial duties of disbursement and of furnishing requested information as specifically outlined herein.
Thank you. Could we now go to page 25 of that exhibit? And again, just to save time, if you could, ma'am, highlight that last paragraph there. Thank you. And you don't have to read it again. That's the same wording as what you read before, correct?
Yeah, I think so. Maybe a little bit different at the very, but it's in essence the same, I would say.
And that's an acknowledgement that Mr. Megaro made, right?
Right. That's part. Yeah, it's one paragraph of the several on there.
Right. And you were asked about other paragraphs, but weren't asked about that one in your
right. That's right.
testimony. All right. Thank you. That's all for that one. If we could also go, ma'am, to Exhibit 189, that's the Duffy affidavit. Okay. And while we're on that first page, do you recognize that it's the same exhibit you testified about earlier on direct?
Yes, sir.
Okay, if we could go, it might be on page 2, maybe page 3, if we scroll down a bit. I want I'm sorry, paragraph 3. I do want to ask you something about that. Do you see there on paragraph 3, there's a scratch out and there we go. The initials apparently from Mr. Duffy, that was the one change he made on that affidavit?
I see. Yeah, I see that like handwritten annotation or whatever.
Right. And is that what is indicated to you that Mr. Duffy, in all likelihood, made that change, and that's the only one on that exhibit?
Right. It seems to be what it is. It looks like JD initials.
Okay. Okay. If we could scroll down a little further, actually, it's to paragraph 11, whatever page that is. That is on. Okay. Ma'am, if you could just highlight 11 for me. Mr. Tarleton, could you read for the panel that paragraph?
Yes, it says neither Mr. Megaro nor anyone from his office ever entered into any agreement with multi-funding with respect to any advances extended to either McCollum Brown or Geraldine Brown. He was not a party to any agreement or contract, nor did he guarantee, approve, or co-sign the advances.
We could go to Okay, paragraph 13, could you highlight that? Does that go on to the next page? I'm not sure. Okay, let's leave it there. You see paragraph 13 highlighted. Could you read that paragraph for the panel?
Yes, sir. In 2016, Mr. McCollum contacted me directly and requested additional advances. This is common with our clients, or out clients. I think it's a type of approximately 80% of our clients request additional advances after their first and the subsequent advances. Again, Mr. Megaro is not involved in these transactions.
And then keep reading. That continues on the next page with except
To acknowledge the existence of the liens. Mr. McCollum granted to multi-funding as a result of the advances. Everything with respect to the first advance applies to the second, third advances, with the exception that neither Deborah Pointer nor Kim Weeks were involved at all with respect to the second and third advances.
All right, thank you. Thanks. I think that's all the exhibits I need. Appreciate it. Just a few more questions.
Yes, sir.
I know you're a new father and
Thank you.
Now, in the motion to terminate Megaro as an attorney, you disclosed to the court that the North Carolina State Bar had a pending grievance against Mr. Megaro. Do you recall doing that?
That was filed by, the motion to substitute counsel was filed by the new lawyers.
On your behalf,
That's right.
representing you, and there were six lawyers on that pleading,
Yeah, probably, yeah.
all representing you. And
Yes, sir. And Leon, well, Dwayne Gilliam on behalf of Leon Brown. Well, actually, I may have spoken too fast. That may have been a separate filing. I've got it. I can.
well, what I'm looking at, if you have it, is it's a pleading that is number 281. It's a styled reply in support of motion to substitute counsel for Raymond Tarleton as guardian ad litem for Henry Lee McCollum.
Right. I was referring to document entry in the civil case at 278, which was the motion to substitute counsel for Raymond Tarleton, guardian ad litem for Henry Lee McCollum. But I think there was a reply filed too, to a response, I think filed by Mr. Halscott.
Right. So this would be the third filing. There's
Right.
a motion, response, reply.
Right.
And do you have that in front of you?
Not the reply. No.
Oh, okay. If you'll trust me, I'll just read to you what I'm talking about in that reply.
May I request what exhibit is this so that I can look at what we're talking about as well?
Well, we'll call it an add-on. It's 170. We would.
Oh, this
it's not on our list.
It's not in your materials. Okay. Can we hold on one
But
second?
it's a public document.
I understand, but
Can we identify again what it is? This is the reply.
Reply in support of motion to substitute counsel for Raymond Tarleton as guardian ad litem for Henry Lee McCollum. It is document 281 filed April 25, 2018.
And Mr. Walhall, do you have a copy of that document?
somewhere, I'm sure it's in our materials somewhere. If I could just have a moment to find it, if that would,
Certainly,
thank you.
Sure.
unless Mr. Williamson has an extra copy.
I might. Is it on this thumb drive?
Oh, thank you. All right. $281. Lane. 281.
Yeah, document entry.
All right, thank you. I'm ready.
Okay. I know you don't have it, Mr. Tarleton. I just want to read it to you. Now, this was filed on your behalf, correct?
Yes, sir.
And what I'm looking at is page 3.
Okay.
And it begins about the middle of the page. As a threshold matter, recent media reports suggest that Mr. Megaro is under investigation by the North Carolina Bar for potential ethics violations. And it goes on to say the investigation reportedly centers on Mr. Megaro's alleged collection of a contingency fee of 1/3 of the $1,500,000 that Mr. McCollum and Leon Brown collectively received from North Carolina related to their wrongful convictions and for improperly approving high interest loans and payments to third parties on the brothers' behalf. And it cites an article written by Joe Neff entitled "A Lawyer Who Helped an Exoneree Blow Through $750,000 is Under Investigation on behalf of the Marshall Project." That was 5 days earlier. It goes on and it talks about that also the North Carolina Bar is reviewing an allegation that Megaro abandoned a North Carolina client after she paid him thousands of dollars to appeal her divorce case. And finally, while Mr. Tarleton and proposed substitute counsel are well aware that there has not been a final adjudication of these alleged ethics violations, Mr. Tarleton is appropriately concerned that a lawyer laboring under the specter of a high-profile ethics inquiry cannot effectively prosecute Mr. McCollum's claims. So I take it from what's represented in this motion that you were aware and approved of your counsel making that as part of this pleading.
Yes, sir. I was.
And you are also aware that at that point there had been no public disclosure of the State Bar's investigation.
I'm not aware of that.
Or there had been, let me rephrase that. There had been no authorized public disclosure because there had been no DHC complaint filed, because that would not be filed until months later.
It's beyond what I noticed, sir.
Okay. Are you aware that the investigation of grievances by the State Bar is confidential up until the point that it goes to the DHC and a complaint before the DHC is filed?
I know your experience. I just can't say I'm personally aware of exactly the timing of everything with that process, but I understand you're very experienced in this area. So I'm not disputing what you're saying. I just can't. I just don't have, I don't practice in that area of law, sir.
Well, okay. But you're a member of the North Carolina State Bar.
That's right.
And presumptively familiar with the rules and regulations that govern the North Carolina State Bar.
I try to stay up to date. Yes.
And part of that is if there's a grievance that remains confidential at the point you were at in this case. Were you aware of that or just didn't know?
Didn't know, not aware of it. Whatever. I just don't know.
Had you had at this point any discussion with Mr. Ken Rose about any pending grievance that he or anybody else had made against Mr. Megaro?
I think I knew that Ken Rose had made a grievance.
How did you know that?
I think Ken Rose told me.
Told.
Yes, sir.
What did he tell you about that?
That he made a grievance.
Well, did you have a discussion with him about that?
Yeah, I mean, we stayed up to date with each other on this case.
did he tell you that he had spoken to a reporter about it not 5 days before this pleading is filed?
I don't know about that.
Right. All right. So anyway, you thought that was fine to put that in here. You approved it.
Yes, yes, sir, I did.
Still do?
Yes, sir.
I want to get back to any discussions you had with Ken Rose. How many times have you spoken to Ken Rose about the McCollum matter?
I'd be taking a guess, but it's definitely probably more than 10 or 20 times.
More than 10 or 20.
Yes.
And what generally have you discussed with him?
The history of the whole case, from when they were interrogated, all of the first trials, the retrials, the years of MAR litigation, Henry's well-being. You know, Ken Rose is still in regular contact with other people who really care about Henry, and they've helped out. They try to still help out Henry to this day, with other people that were a part of that kind of whole post-conviction team that led to his exoneration.
How many times in your discussions with Mr. Rose has a topic arisen at all relating to Mr. Megaro?
Numerous times, but I couldn't give you an exact number.
Okay. And what have you discussed with Mr. Rose about Mr. Megaro?
That he was exploiting Henry McCollum.
That's the extent of the discussions that you had?
No, it's obviously, it is more detailed than that. But I don't have, you know, what's that?
Can you give me some of the detail that Mr. Rose was telling you about
Sure.
Megaro?
Sure. One thing that jumps out is sort of the whole history of what happened. That Ken Rose, I guess other people working on the post-conviction team, after his convictions were thrown out by Judge Sasser in September of 2014, that the next step that they were taking was to try to obtain a governor's pardon of innocence for Henry and his brother Leon. That they had filed a petition with the governor's office, that they'd gotten the elected district attorney of Robeson County to get on board, that elected DA wrote a letter to the governor saying that, outlining the history of the case and why he thought the brothers' civil rights were violated. That that Mr. Rose continued to work with the governor's office at the governor's office request and the governor's council for his input into basically at that point it's still just an innocence issue. It wasn't, the governor's part of the innocence wasn't getting into civil rights violations. It was getting into, are they actually innocent, right? Because that ultimate question hadn't truly been reached in the MAR litigation. So Ken Rose continued to work at the governor's office request to do this inquiry, and where they simultaneously had the SBI out doing a purportedly independent investigation into whether pardons of innocence should issue. And they were critical, because if the pardons of innocence issued, then each brother is automatically entitled to $750,000. And Ken Rose has been a part of, like, and his team have been a part of numerous, from my understanding, cases where people are exonerated and they get industrial commission money. And
Say that again.
Ken Rose I don't think this is the first exoneration case he's been a part of, and so he understands the process of all of this, and so he was very helpful in me understanding all that, and helpful for me to understand how Mr. Megaro became involved, and that he all of a sudden Ken Rose got a letter, despite decades of representation of Henry trying to secure his released from death row got a letter one day that from Megaro that he was representing him and that Ken and then were to have no more contact with Henry McCollum about I guess the pardon or the future lawsuit, or I guess anything else within the scope of Megaro's representation. So, you know, he was very important for helping me understand how Henry McCollum became isolated and ultimately wound up in a situation where hypocritical and conflicted positions were being taken in this civil litigation by Megaro.
Did I understand you to say, and I may have misheard you, that you understood that Mr. Rose had represented clients who had previously gotten compensation from the Industrial Commission?
Or yeah, that he knew how the process worked.
Well, that's a little bit different. Did he say to you that he had clients who previously he had represented that were able to get compensation from the Industrial Commission?
I think it was more in lines of he knows how the process works from other cases.
Not his.
I don't know. I'm assuming he's, I don't want assumptions. So
Yeah,
I'm
no
assuming
assumptions. Well,
Yeah.
unless you're comfortable making them, but I'm not
Yeah.
looking for assumptions, looking for
yes, sir.
call them your best recollection.
To my best recollection, he helped me understand that whole process.
Did he tell you that he had gone through that whole process, with getting compensation from the Industrial Commission?
I don't recall him naming a specific client.
Okay, I really am just about done. When was the first time that you spoke to anyone from the state bar regarding the McCollum situation?
I can't. It's probably I want to say several years ago. The bar prosecutors or the attorneys reached out to me, wanting to talk about the case, in the federal litigation.
You say the attorneys reached out to you. Is that Mr. Murphy and Mr. Walthall?
Yes, sir.
Yeah. And they reached out to you several years ago?
I think so. I mean, I can't remember.
You don't have to speculate. Just best.
All right. I'm going with several years ago. Maybe I should. Yeah, I'll say several.
Okay. Well, that could mean several things, but how many times, to your recollection, have you communicated in any fashion, either in person or over the phone or by text or email, with the state bar regarding Mr. McCollum and Mr. Megaro?
I would think probably at least 15 or 20 times, maybe even a little bit more. But I'm just kind of guessing too, like, you know.
And when was the last time you met with the attorneys for the state bar?
It was the week after February 26th. I just finished a federal criminal jury trial. So it was that Monday or Tuesday following. Friday was the 26th. Either that Monday or Tuesday, I believe, without looking at something.
Did you engage in any preparation with them in anticipation of your testimony today?
Yes, sir.
Okay. When did you do that?
That's what I mean. They it was the week after the Friday was February 26th at the new trial, and then it was either that following Monday or Tuesday. And I met with Mr. Walthall for a good while, going over, my recollection of things and looking at documents.
You say for a good while. Do you have a time estimate about how long that meeting lasted?
At least 2.5 hours, I think.
And were there any other, what I would call preparation sessions for your testimony other than that one time?
I don't think so. I mean, I've been given calls about like scheduling on for this. And so if like my substantive testimony, that's what comes to mind is that meeting where we went over my recollection of things and documents. The scheduling with the newborn and everything. I've had several calls and about that, and cleaning up getting the Zoom link and what time I would testify today, for example.
Let me ask you, specifically, I'm switching a little bit here. Do you recall that you had any discussion with Ken Rose about Mr. Megaro after you were appointed as guardian ad litem, but before you met Mr. Megaro at that June 21, 2017 meeting?
I can't say for certain that I had. I want to think that I had talked to Ken Rose before that June 21st meeting, but I don't know that for certain.
It was several years ago.
Yes, sir.
But best of your recollections, you think you probably did?
If it wasn't right before, it was probably soon after. I definitely talked to Ken Rose by in the summer of 2017.
I really am about through here. Going back to this pleading on your behalf, where you talked about the publication of the pending grievance against Mr. Megaro, there's also pointed out there about an allegation that Megaro abandoned a North Carolina client after she paid him thousands of dollars to appeal her divorce case. Now, that didn't have anything to do with Megaro, did it? I mean, excuse me, with McCollum.
I would say modus operandi.
Oh, that was a good idea to reveal that simply to show you think that that he might be some ethical, generally lawyer. Is that what you?
The lawyers, yeah. There's a pattern, and the lawyers and I made the call that when he was not agreeing to walk away as counsel, this needed to be filed with the federal court.
You have no idea whether at any point that allegation in that divorce case has ever been substantiated.
I don't have personal knowledge of it.
If I could have a moment. Thank you, Mr. Tarleton. That's all the questions that I have for you. It's possible you might have some more from our counsel.
Any redirect?
No, sir.
Mr. Morris? Any questions, Mr. Bennett? No. All right, thank you, Mr. Tarleton.
Thank you.
Will there be further evidence for the state?
No, Mr. Chair, we would just at this time, and I'll handle these in stages, just anticipating perhaps some pushback on one of these. I would at this time respectfully move to admit into evidence the exhibits listed in the pretrial stipulations based on the fact that they've been stipulated to, and here at the close of our evidence would move to admit them.
Let's talk about that. The stipulation that you have indicates the exhibits. Sorry, is it off? Not picking up. Is that better? Thank you. The stipulations say that the exhibits may offer at the hearing. My concern is there are a number of documents, some of which even appear to be, for example, videos that we're supposed to look at YouTube and so on. I don't know how to admit those and then make decisions on the case without reviewing all the evidence that's presented. And so my concern is that that rather than just as a blanket to say all these documents are admitted, realizing the authenticity of them is, has been admitted. Short of us reviewing all those documents, I'm not sure what to do with them.
Yes, sir. And so if I may, the State Bar does not have any videos, I don't believe, on there.
I guess it's in the defendant's
I believe
link,
those are the
perhaps.
defendants, and I think it would be their prerogative at the close of their evidence to move to admit those.
But that's fine. But there are, I mean, there's, we certainly have not gone through all the exhibits right on your list.
I think with the timeline, we've gone through almost all of them, but you're correct. There may be one or two that we have not specifically talked about. Thank you.
What I'd like to be able to do is have the exhibits identified that you intend for us to rely on in making decisions in the case. And maybe you have, I have, because they weren't admitted as you've spoken with them, I've written down the exhibits as we've gone through them. But since they weren't admitted to evidence, I have not flagged them as the ones that the State Bar will be offering. So, and I just need your assistance either by exclusion, telling me the ones that you do not believe we have addressed or will not be relying on for purposes of making a decision in the case, if there are such exhibits, and we can do it overnight if we need to, but I think that unless you're counting on us reading all the exhibits, including the ones that you have not introduced, then I think we need to identify the ones that you do want us to rely on.
Sure, and we can do that. I can go through and indicate which ones we have brought up in any of the witness examinations so far. It would take probably a little bit of time, and I apologize for that. We can do that. I can also just forecast for you. It's our intention to both in our closing and in some hard copy binders distribute to the panel, and obviously, give a copy to the defendant as well. Hard copies of some of these exhibits that we believe are the key exhibits that we'd like for you to look at as you're making your determination.
Well, to be clear, we'll look at every exhibit that has been stipulated to, that has been referenced by the State Bar. What I want to avoid doing is searching for documents that have not been referenced and you don't intend to reference going forward. If it's been introduced to evidence, I think we have to review them. So.
Sure, and I'll say, I don't think there's a document on here that we either have not looked at or do not intend to bring up during the defendant's case in chief.
Right. What I'd like you to do then, I think, is maybe just review that overnight. We'll address that first thing in the morning.
Yes, sir.
Mr. Williamson, do you have a forecast as to, we talked about this at lunch, but do you have a forecast as to where you are in your case? Again, taking as much time as you need to take, but just to get an idea for the panel where we're headed.
I think I was probably a little naive when I said there was a possibility we could put on our case by the end of tomorrow. I certainly think that we will be done on Thursday. I can't see taking more than 2 days. Which we're talking about phase 1. I don't anticipate having a great amount of, I do anticipate having some phase 2 evidence, which is not always the case. But this is a case given, of course, the posture that not under my control how much time, because State Bar has the right to cross-examine that talking about our case, I feel pretty confident. I will simply say I am mindful of the panel.
No, I appreciate that. I appreciate that.
Not to waste.
Mr. Williamson, also over the nighttime break, if you don't mind, the issue I raised regarding the pleadings, I'd like to sort of get that clarified so we know which are admitted and which are not.
Yes, and I apologize. I know you asked for that. You know how it is when you're.
No, that's okay. I didn't expect you to do it today, but.
Okay, we'll do, certainly.
Is there anything else we can accomplish before the evening break?
Lane, did you have a motion you wanted to make?
Well, before I set about motions, I think it would be helpful to me to know what they're relying. If we could wait till tomorrow morning. I think immediately if I see what it is that they intend to focus on.
You mean in terms of the exhibits, you mean?
Yeah, and I'll tell you I'm really not very concerned about these documentary exhibits, but I would like to know, there are 3 video depositions that I think in some way we've stipulated to their admission. The Weeks, well, there might be 4, I don't know. There's Weeks, Pointer, the 2 consultants. There's Duffy, the multi-funding fellow. And there was Geraldine Ransom. Those are all depositions. We haven't had any.
Well, this goes to my point that I was talking about earlier with.
I know. That's why I'm bringing it up again. I'm not necessarily objecting to the use of it, but I'd like to know, well, are you using it? And if so, what portions? We've not had a designation under Rule 32A5 of, portions
Of the depositions to be
I
used.
don't really, I'm kind of at a loss. The other point I would make, and this is an accommodation I would like to ask for. I anticipated, well, under the rule, say we had no stipulation. Under the rule, Weeks, Pointer, Duffy would all be unavailable and they could use those. But Ms. Ransom lives in, I believe, Fayetteville. I'm not sure, and I thought she was on their witness list. I thought she would be here. I thought we had the opportunity to examine her at this hearing. Now, I don't, maybe given the stipulation I've entered into, I may not be able to object to their using it, but I would like to have on the record what efforts they made to get her here, since she could be subpoenaed, and why she apparently must be unavailable. Otherwise, they would have gotten here. I would just like to have that on the record.
Anderson, we talked about it at the pretrial conference. Mr. Walthall, do you anticipate using any of these other depositions that he's referenced?
Pointer, Weeks, and Duffy. Duffy, we've already looked at several.
I'm sorry,
portions
Duffy's
of it.
deposition is in. We've already examined that.
Correct. Pointer and Weeks, we'd like to reference. We don't plan on playing the videos or even moving to admit the videos into evidence, though we would have no objection if Mr. Williamson would like to do that. We do not intend to use any portion of Geraldine's deposition.
Okay, I guess what I would like to know kind of beforehand, before we put on our case, if they're going to reference that, say, an argument, I'd like to know what it is.
Well, I think that, again, going to the point I was making a minute ago, in introducing evidence before the panel, we need to identify the documents they intend to rely on. And if those include those depositions, I'm sure that'll be in the list that he has
Right.
provided. And I understand your point about what the rule provides in terms of the use of depositions, part of use, or when it can be used, and those kind of things. That, of course, would be stacked against whatever stipulations the parties have always made regarding their admissibility.
Yeah, and I'm not making a big deal about it. I just, for instance, if I make any motions or structure my case, do I just make it on the assumption that I've got to address everything in all those depositions, or would they be willing to say, well, we're going to talk or have the panel focus just on these portions? That would be, I think, fair.
Yeah, Mr. Walthall, I tend to agree that rather than having him prepare for an entire deposition, if you could somehow focus, if you intend to use one of those depositions that you've mentioned, if you could focus on the areas, and may I suggest that one way to do that, of course, you can prosecute the case any way you want to prosecute it, but you certainly could identify for the panel the sections you want us to read, and you could do that without a witness, in my opinion, since they've stipulated to their authenticity and admissibility at this point. And then the panel could read those sections, and that would give Mr. Williamson then notice of the sections that you intend to rely on?
Is that for Pointer and Weeks, but not Duffy, since we've looked at that deposition? I've
Duffy's
already
deposi-
highlighted the pages. that we
I think
wanna talk
Duffy's
about.
deposition we have examined.
Okay,
And we
great.
understand the areas that you intend to ask regarding Mr. Duffy and his affidavit for that matter.
And absolutely no objection to informing everyone what pages of the Pointer and Weeks depositions we plan on using. That certainly is our plan.
Does that solve your problem, Mr. Williamson?
Yes, it does. That's just kind of like designated portions of the deposition we would do normally.
Do cuts, right, like we do the cuts in a typical trial deposition, trial
Right,
case.
and we'll do the same. We'll do the same. We might not have it tomorrow. During the course of our case, we will also do the same. I will tell you, there's probably a little portions of Geraldine Ransom that we would also see.
All right, sir. Let me suggest that perhaps the council could get together maybe 8:45 in the morning and just exchange whatever exhibit list you've got there, Mr. Walthall. And then we can then begin with the presentation of evidence from the defense at 9 o'clock. Also, Mr. Williamson, will you provide to the State Bar some sort of forecast of the witnesses that you intend to call tomorrow in the order, if you know,
Oh, sure.
so that they can
Yeah.
likewise be prepared? Thank-
What we did last night was we conferred, or they conferred, and they emailed it to me, which is fine. We'll do the same. I'll email it to,
Well, we told you who they were
Walthall.
first.
Huh?
We told you who they were first, and then we emailed you the order.
yeah.
So
Okay.
if you could tell us
Well, I
now
can
who we-
tell you for sure tomorrow, the two, Harbin and Bellard, Amy Housecott. Okay, yeah. Patricia Armenteros and Joe Easton. Got through those, it would be a lot.
Well, I congratulate both of you so far. You've done a good job parceling out the evidence for us to consider, and I hope that we continue on this path. So we'll get through it one way or the other. We'll get through it.
And I will say, in terms of the order, for sure, the two experts are going first.
Dr. Harbin and Dr. Ballard.
Yeah, probably Harbin first and then Millard. Is that right? Yeah, that's it. I think that's how it'll be, barring unforeseen circumstances.
All right, then if anyone doesn't have anything else, then we'll be at recess and see everyone in the morning. Thank you very much. Have a
Thank
nice night.